ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಡಿಯೋ ಇಲ್ಲ. ಕೋರ್ಟ್ ಆಡಿಯೋ ಇಲ್ಲ.
ಸರ್ ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೆ. ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆಯಲ್ಲ, ಎಲ್ಲಾರು ಮಾತಾಡೋದು ಕೇಳಿಸುತ್ತೆ, ಅದಕ್ಕೆ ಬಂದ ತಕ್ಷಣ ಆನ್ ಮಾಡ್ತೀನಿ. ಸರಿನಾ ಸರ್?
ಆಗ್ಲಿ ಆಗ್ಲಿ.
Madam, fresh one. We'll see. We'll see. We'll see. That matter next week. Yes. Yes, next week. Yes. Next week. Yes.
Next week.
Tomorrow. Yes. Which year is that?
2025.
We'll see. Yes.
One matter for tomorrow, the petitioners are directors of cooperative society. Without notice, they have been disqualified. On 16th, they are holding the election, keeping set aside this petitioner. Therefore, tomorrow.
Yes.
My matter, my lord, two matters. They are covered by the decision of this honorable court. I am for the respondent. I concede that the writ petition may bear.
We'll have it next week. Yes.
Let's one matter.
There are two matters.
This matter of the year 2021. The demand notice issued by the secured creditor. Let's challenge in this question, this petition. I am for the bank. Since 2021, the
Yes.
has not.
Registered deed cancelled by the revenue authorities.
When is the writ petition?
My lords, 23, 2023.
20?
2023.
It's 26, sir.
2023 matter, my lord.
We will see. Yes,
My lords, one for withdrawal of petition, my lords.
tomorrow. Yes.
One fresh matter for tomorrow, my lord. James is that, my lord, DRCS without authority has stayed the president and vice president election, my lord.
Huh? Switch on the mic. I'm not able to hear.
Without authority, DRCS has stayed the president and vice president election, my lord. There is some emergency. Kindly tomorrow, my lord.
When
Fresh
was it? When was it?
in last week, my lord.
Fresh
matter,
next week.
Not
There are
fresh.
so many already fresh matters are given. Court can't take up
This
here.
is fresh matter. This is also fresh matter, my lord.
Two matters.
Huh?
This is also fresh matter.
It
my
will
lord.
come here. Then you should have given it.
Fresh.
Fresh
Yes.
matter.
Two matters for GMCPC, madam. Trial court proceedings are being stayed. FDP proceedings.
Which year is that?
One is 24, madam, one is 25. In one petition, I have no
We will
objection
see.
to
We
allow.
will see. We will see. Yes.
My lords,
Please,
one
next.
MFA matter, my lords. It's a case
Speak
of,
thereafter. Yes.
one MFA matter, my lord. It's a case of amputation, my lords.
Case of?
Amputation, my lords.
Hmm.
So kindly tomorrow, my lords.
Which year is that?
23, my lords.
Yes.
My lord.
Take it.
One matter for GMCPC, my lords. One matter for GMCPC, my lords. Preliminary and B group is, my lords.
Huh?
The respondent has not given the e-khata utar, my lords.
We will
Madam,
see. No urgency
week-
for
next
that.
week,
It can wait.
My matrimonial dispute is ended in compromise, my lord. The respondent is working in Hiscom, my lord. In earlier point of, as per direction of this honorable court, has released the amount. Now asking another direction for release of the amount, my lord. Stay is granted, my lord. I requesting the honorable court to direct the release the amount, my lord.
How can they ask for a
earlier-
direction in
earlier-
spite of there being a direction?
My lord, in respect of particular amount, this court has directed, my lord. Subsequent amount is not there.
Next week. Yes.
Please, please.
State appeal, your lordship. MFA, quantum, we have challenged the quantum, your lordship, as interest will increase, your lordship, that is.
Fresh matter.
No, 23, 22 matter.
We'll see next week. Yes.
Milords, both pending matters. One is for mandamus, Milords. One of my agricultural land is encroached by the school. I had submitted representation. Any date convenient to your lordship, Milords?
A week thereafter.
Date may be given, Milords.
Yes.
Fresh matter, my lord, company appeal. Fresh matter, insurance company appeal.
Fresh matters, give it to the court officer. Yes.
Fresh matter.
One fresh matter, my lord.
Fresh. Give it to the court officer.
Fresh matter. Fresh matter ಇದ್ರ ಕೊಡಿ.
Yes, call the list.
GMCPC matter, my lord. Next. GMCPC matter.
When was interim order granted?
In 2023, my lord. Thereafter, it was not listed. I am for the respondent.
So we will see. We will see.
Next week, next week.
Not possible for the court to take all the matters. Yes. Call the list.
Adjournment.
Petitioner is a mentally disabled daughter of a KPTC
Huh?
employee. Petitioner is a mentally disabled daughter of a KPTC employee. I am seeking pension, madam. Any date is
Which year is that?
last year, 25.
Huh?
25.
List is matter in the month of February. Yes.
Petition is a cooperative society. There is an interim order passed by this honorable court not to count the votes. Election was held on 28/9/2025.
Next week. Yes.
Page wise adjournment. List number 1, page number 1, serial number 1. Page number 2, serial number 2 to 4. Page number 3, serial number 5 to 8. Page number 4, serial number 9 to 10. Page number 5, serial number 11 to 14. Page number 6, serial number 15 to 20.
Let's serial number 20. Appear for petition, Milords. I pray for week's accommodation.
My lord, serial number 20, my lord, it is a DRT matter, my lord.
Why do you want time?
Milords, we are complying the order. This honorable
Not
court
about
had
the
granted.
complying of the order. We'll hear it.
Please.
All these DRT matters they need not be adjourned. Yes. Yes.
Page number 7, serial number 21, 22.
Let's serial number 22. I appear for petition. May I request it tomorrow, Milords?
Have you informed the other side?
Yes, Milords, I have informed Pallavi.
Nande Pachapure.
I'm appearing for the other side.
Tomorrow it is not possible.
I filed my application for vacating stay, my lord.
That's why tomorrow it is not possible. If it has to be adjourned, it will be after, on,
Monday, my
maybe on 21st,
lord. Monday, my lord.
21st.
Please.
List is matter on 21st at the request of the counsel of the petitioner.
Interim order may kindly be extended.
Tomorrow earlier granted is extended. till
Great,
then.
Milords.
Page number 8, serial number 23 to 25. Page number 9, serial number 26, 27. Page number 10, serial number 28 to 32.
Serial number 31, my lord. I have informed the other side. 2 petitions have been filed by one by the husband and the another by wife. I seek a, due to personal inconvenience.
In which
May-
matter you appear?
In the second matter, it's my petition, my lord. In the first matter is already.
On counsel, appearing WP number 108796. This is 2 matters, on 17th of February.
Please.
Some urgency in this matter, my lords.
Next
I am
week.
appeal for the
In this matter.
In the very matter, my lord.
May be taken on 19th or 20th. my lord.
Yes, 20th.
It is, my lord.
Serial number 11, serial number 33 to 38. Page number 12, serial number 39 to 46. Page number 13, serial number 47 to 54. Page number 14, serial number 55 to 60.
Serial number 58. There is a one more matter, 58 man. I'm appearing for response. I have also informed the other side. There is the one more matter by the.
This along with so and so on 22nd.
26th Jan. Yes. Page number 15, serial number 61 to 64.
My lord, 64, my lord, 64. Serial number 64. There are two insurance companies. Baddi has appeared for two insurance companies. Therefore, he has given no objection to Reliance. Therefore, 1 week time may kindly be granted. I will file wakalat and go on with the matter.
After 2 weeks. Yes, next. Second list.
67.
60.
Yes.
Page number 16. 65 to 67.
65, my lord. 1 week of time, my lord.
Why? MFA matters 23 final hearing will complete it. Yes.
My lord, 67. Week's time may.
67.
67.
Why a week's time? It hardly takes
Lord,
5 minutes.
It's on no DL point, my lord.
Then we will hear it.
I will file the synopsis, bullet synopsis in this matter. Week's time may kindly be granted, my lord. On 20th, I will finalize.
MFA, it's all settled law. No synopsis is required for this.
No, my lord, it's, as per the recent Supreme Court judgment, no liability on the insurance company.
Yes, I'm aware of it. For that, why do you require to file all that?
But it is the old matter, means prior to amendment.
Then it will not apply.
No, it's applicable, my lord. It's a fixed court judgment is there. So kindly week's time may kindly be granted.
Week's time, finally, no further time. Have you informed the other side?
Please, ma'am.
Yes, it is submitted at the, I've already informed to the other side. Yes.
List number 2, page number 1, serial number 1 to 4. Page number 2, serial number 5 to 11.
Serial number 7, my lord, notice is awaited. Interim order is.
That we will do it when the matter is called. Only adjournments, please mention.
Page number 3, serial number 12 to 19. Page number 4, serial number 20 to 23. Page number 5, serial number 24 to 29.
Serial number 25, my lord. There is no interim order in the matter. Kindly have it on next week, my lord. My lord, elders of the family are trying to settle the matter among themselves.
No, you can settle the matter after disposing of this also.
My lord, kindly, my lord. I am Praxi Counsel appearing for petitioners. 1 week time may be given.
This is matter in the month of March. Yes.
Serial number 28, my lord. I'm for the petitioner. 2 weeks time may be given.
You have an interim order?
Sorry, ma'am?
You have an interim order?
Yes, my lord.
Then why should we grant 2 weeks time?
On record, counsel
Have you
has.
informed the other side?
Please, my lord.
If he has no objection, list this matter in the month of March.
Interim order may be extended.
Interim order earlier granted is extended until further orders.
Gotcha.
Yes.
Page number 6, serial number 30 to 36.
Serial number 32.
Yes.
My lord, a week's accommodation, my lord.
You appear for whom?
Appearing for the petitioner, my lord.
Have you informed the other side?
Lord, other side is, my lord, practicing in trial court, my lord. I am no, yes, my
Then
lord.
please wait till the matter is called. Yes.
Yes.
Page number 7, serial number 37 to 39.
Please call the list.
List number 1, orders matter, serial number 1, GN Raichur.
My lord, I am for the appellant in this matter, and the liability itself is under challenges. Investigation report, everything has been produced. Therefore, whole matter, if records comes, whole matter may be heard. I have no objection. But release.
They're on the liability.
Yes, my lord. The records are necessary, my lord, in this case. And meanwhile, I am filed the application, my lord.
Raise this little bit. Yes. This is directed to call for the record, call for the LCR.
And my lord, in connected matter, my lord, that is MFA 102438, my
Along
lord.
with so and so. This is matter once the TCR is received.
Please.
Yes, next.
Serial number 2, Vadiraj.
A week's time.
Week's time.
A week's time is granted.
Serial number 3.
Process in respect of R2 to
My lord.
R4, or else the appeal shall stand dismissed against our,
Interim order may kindly be extended.
against CPC matter. 24, even till now you have not paid the process or the first time?
No, no, my lord. In last appearance, the council has given the.
1 minute. The petition is permitted to take out hand summons on the council appearing for respondent number 2 to 4 before the trial court and shall file a memo to that effect by 29th of January, or else the interim order that is granted by this court stands vacated.
Yeah, as per my knowledge, my lord, there is no interim order as such. Idralli ಏನು ಇಲ್ಲ.
Give the
ಇಲ್ಲ.
file. Respondent shall not precipitate the matter.
Please, sorry, please.
Yes.
Serial number 3.
Number 3.
The
matter
tender
pertaining
matter,
to
my lords,
tender.
it may be taken along with serial number 63.
Tender matter.
90 days period, my lords, wherein.
Along with that.
Please.
Let's serial,
with 16.
serial number 24 also same, my lords.
Along with the
3,
60.
16 and 24.
Serial number 3 and 4, serial number 24, and along with 62.
Give the number to the court officer. He'll call all matters along with the last matter.
Great.
Please.
Yes, next.
Serial number 5.
4 also same.
Yes.
3, 4. Pass over. Serial number 5. Subendu Akalwadi.
Office objection shall be complied with within a week, or else the writ petition shall stand dismissed. Yes, 6.
Serial number 6.
In this, I am for the petitioner, my lord. I have filed the present petition in respect of challenging the order of the trial court, where my amendment application, I am for the defendant in the trial court. Amendment application to the written statement has been rejected. Against that particular order, I am before this honorable court. In fact,
What is the suit for?
suit is filed by the son-in-law against mother-in-law for recovery of money.
Recovery of money.
Money.
What is the amendment now?
Amendment in respect of the property in question for which he had transferred the amount for the loan. That was a housing loan. That particular property has now been declared by even by the apex court that it is a joint family property and it is not the absolute property of this particular lady. So I want to incorporate all those factual matrix which has been disposed after SLP.
No, suit is which year?
So 2014,
2014 suit. When was the SLP disposed of?
2022, if I am correct.
24.
2024.
When was the amendment?
Amendment recently filed, a month back.
25.
Yes.
Now please come to the order.
When the matter is posted for arguments.
Let's see the order. Page number.
Before that, my lord, may I request one interim, one order was challenged before this honorable court.
No, we'll read that. We'll read that and then again come back to this.
Because
You can make your submissions on that.
because in interim directions, a liberty was given to me in the earlier writ petition, that is page number 110. May I request?
That is subject to the satisfaction of the court.
Yes.
So please come to the impugned order now.
The reasoning starts from, my lord, is from, I can say, the page number 10 is my pleadings, para number 10. It starts on going through the proposed amendment. The defendant wants to incorporate the pleadings of OS 100/2011 and filing of RFA so and so and SLP of so and so, stating that the said appeal was dismissed on 9/2/2024. And in view of the said judgment, all her family members who have got share in the said property are equally liable to pay debts.
Page number is the impugned order. I'm not able to see that.
Page number 132, ink, page number 132, ink page,
Yes.
para number 10,
Yes. Let's read from point number 9.
point number 9. Point number 1, that is the present IA is pressed into service by the counsel for the defendant to amend written statement when the matter is posted for defendant side arguments. On going through the affidavit averments, the reasons assigned by the defendant for amendment of the written statement is that she has been under the impression that she is the absolute owner of city survey number so and so, and she has been pursuing legal proceedings challenging the judgment and decree passed in OS 100/2011, that she had preferred RFA 10,289/16 and SLP number 2838/20 24 before the Honorable High Court of Karnataka and Apex respectively, and came to be disposed of on 9/2/2024. She claims she has bona fidely belonging to the absolute owner of the property bearing CTS number so and so. She had made lot of efforts to safeguard, improve, develop property, and for the same she had incurred financial as well as litigation responsibilities. That is the subject matter involved in the present suit is for payments of debts incurred on the property. Hence, it is necessitated her to saddle the responsibility of paying the same on the other family members. She also claims that during preparations and filing of written statement, certain facts was left out to be incorporated in the written statement due to the oversight and bona fide impression that she is the absolute owner of the property in question. Therefore, in view of the changed circumstances and ownership of the property, it has become incumbent on her to seek amendment. On going through the proposed amendment, the defendant wants to incorporate pleadings about OS 100 by 2011 and RFA number so and so and SLP number so and so, stating that the said appeal was dismissed on 9/2/2024. And view of the said judgment, all her family members who have got share in the respect of the said property are equally liable to pay the debts attached to the property, and they are also parties in OS 100 bar 2011 and also necessary parties to the suit. By way of introducing para number 15A, the defendant has sought to amend written statement to the effect that the daughter of defendant herein had filed OS 95 bar 2014 for recovery of money, and her granddaughter of defendant had filed OS 96 bar 2014 for recovery of money, and the claim made by them in the above said suits and the claim amount paid to Graha Finance Limited is false. She wants to deny the claim of the wife, daughter of the plaintiff about payment of 45 lakhs to the Graha Finance as illegal and falsification. Defendant also intends to incorporate certain pleadings about the suit suffering from non-joinder of necessary parties who are parties in OS 95 by 2014, 96 by 2014 and FDP 15 by 2014. The defendant also wants to incorporate about the details of payment of money made by her to Graha Finance and borrowing of money by her from various persons and family members, details in the IA. She also wants to incorporate pleadings about the expenditure incurred by her in making improvements in CTS number so and so. And she also wants to levy the burden of paying the said amount and the present suit claim on the other family members who have also received shares in the said property. She also wants to incorporate pleading about her set off in the suit amount, which according to her to be paid by wife and daughter. She also wants to incorporate pleadings about Exhibit P4, stating that the same is created document, and she wants to incorporate in the pleading about Section 34 of the Stamp Act in respect of the promissory note. The defendants for the counsel for the defendants, by relying on the order passed by the Honorable High Court of Karnataka bench in WP 109186 by 2025, argued that there is a direction to consider the application for amendment. However, I have gone through the order passed by the Honorable High Court of Karnataka. In para number 5, said order, it is ordered that in case if application is filed by the defendant before the trial court to seek amendment, same shall be considered in accordance with law after hearing the plaintiff respondent. In view of the said order, the present application is considered in accordance with law. It is pertinent to mention that in the present case, though the counsel for the defendant argued that by way of present amendment to written statement, the defendant wants to incorporate subsequent pleadings about OS 100 by 2011, which was finally adjudicated by the Honorable Apex Court on 9/2/2024 in SLP number so and so, and same is about subsequent event. Admittedly, the present suit is of the year 2014, whereas 100 bar 2011 was filed prior to the filing of this suit. Even if, according to defendant, the Honorable Apex Court dismissed SLP on 9/2/2024.
Where is the original written statement? Switch on the fan. Where is the original written statement?
I have produced. It is at page number 18, my lord, 18.
No, the defendant, the daughter is the only daughter of the defendant.
Yes.
So now what is the necessity?
No, no,
Whether
she
it
is
is a
not the
joint.
one. There are 4 sons, 1 daughter.
Oh, if you look at paragraph number 4,
She is the only daughter, but 4 brothers. My only submission would be, my lord, in view of the order which has been finalized in SLP, all the family members are getting share over the property. So the liability which is casted over the property in question needs to be equally meted out by all the family members who want share over that particular property. That is the only anxiety which
let's
is.
see the pleading in the plain. Where is the plain?
Pleading is
With
at
regard
page
to
number.
how the amount is given to you.
No, no, it is not given to me. It is given to directly to Graha Finance. Bank,
For
Graha
repaying the
Finance.
amount to the
Yes.
bank.
Page
Let's see
number
the-
12, my lord.
Let's see the.
Shall we read from para number 3?
Para number?
3 of the plaint. Graha Finance Limited, Hubli, had advanced housing loan in respect of residential building CTS number 2927. This is the same city survey number which I have been mentioning in OS 100 and RFA and SLP of measuring so and so of Vailapnavar Nagar, Hubli. The property standing in the name of defendant. On account of default in repayment of the said loan, the property was attached in terms of Surface Act. However, in appeal preferred by the defendant before the Debt Recovery Tribunal, Bangalore, the matter was settled. The defendant approached the plaintiff and his wife with the representation that Graha Finance Limited towards recovery of its dues in respect of the house that stood in the name of defendant.
Particular house declared to be a joint family property.
Yes, it is now been declared as a joint
Now
family.
let's see the specific where is that amendment?
Amendment is at page number 114, 114. I have given details in respect of the pleadings which I want to show that in respect of the orders which are passed in OS 100/2011, RFA and SLP, and also the payments made by me individually. That is para number 15D which I want to incorporate, where I have paid individually, taking hand loans from the other family members. I have paid this particular amount.
I can understand this 2A and 2B. What is this 15A?
15A in respect of the amount that I have paid.
Why should you take a stand at this point of time? It is not something which has happened pursuant to the order in the SLP.
It is not, but it is the payment which has been made by her.
Whatever it is always open to you to take all this much right from 2014. So it has nothing to do. If you say 2B, it is outcome of the SLP.
Yes.
So 15A, it
Then
has
as
nothing
regarding
to do.
15D is the payments made by me for improving the
Not necessary to
my
decide it
lord,
now.
my lord, my submission would be, since I was pursuing the matter from 2011 up till 2024, the improvements and expenditure made by me is also at page number, and that is 15D and other things which I want to that is the improvements, additions made by me.
No, whatever you have spent and all not necessary for his suit for recovery of money. That is between, if you say that you require anything, you can claim it from your children. So this is all expanding the scope of this.
But these are the expenditure which is against the same property on which the Graha Finance had financed for a housing loan. And where I had been claiming that it is my absolute property, where I have lost in SLP also. Now that it has become a joint family property where there are sharers.
What do you say?
Let's my first submission is Millets. At the fag end of the Millets suit, they have filed this application. This is first submission. Secondly, Millets, in the earlier round of litigation in RFA Millets, there is a specific direction by this honorable court suit has to be decided within a period of 6 months. Almost 6 years have been lapsed. This is second. Now, by way of this amendment, kindly see the present defendant, that is the plaintiff, has executed a deed in respect of defendant in the year 2009. That is already tested before the laboratory. And the laboratory holds that the consent deed executed by the plaintiff, which is not belongs to the for a moment. Kindly see the even that report is came to on 9/12/2024. They did not challenge it. After lapse of 1 year, fact end of this is now they have filed this application.
No, the fact remains is
Please.
that property is held to be a joint family property. And the purpose of taking the loan or
Yes.
whatever the payment you have made is in respect of that property, isn't it? Now, that particular aspect has crystallized by the order of the apex court in the SLP. You don't deny the fact that that SLP is of the recently that is disposed of. So now 2014 suit, filing amendment at a later point of time, I don't think all will come in the way of the defendant.
Let's kindly see the reasoning assigned by the trial court for a moment.
I have seen
No,
it has gone,
subsequent
it has gone
paras.
more on
Subsequent paras.
yes, I've seen the entire order, but if you want to read which paragraph.
Let's please. Param number 13 and 14 are.
Yes, please read.
Please. It is pertinent to make a mention that in the present case, though the counsel for the defendant argued that by way of the present amendment to the written statement, the defendant wants to incorporate subsequent pleadings about OS number 100/2011, which was finally adjudicated by the Honorable Apex Court on 9/2/2024, SLP number so and so, and same is about to subsequent event. Admittedly, the present suit.
Where?
Page number 135 of my book.
Impugned order para number 13
Para number 13, page number, internal page number 9 of the order.
Yes, please read.
It is pertinent to make a mention that in the present case, though the counsel for the defendant argued that by way of the present amendment to the written statement, the defendant wants to incorporate subsequent pleadings about OS number 100/2011, which was finally adjudicated by the Honorable Apex Court on 9/2/2024 in SLP number so and so, and the same is about to subsequent event. Admittedly, the present suit is filed in the year 2014, whereas OS number 100/2011.
This finding is wrong.
No,
How can they take a pleading about this?
My suit is of the year 2014.
That is true.
Please.
According to you, you have given her the money.
Please.
You have given her the money to repay for in respect of a particular property to the bank. That property is held to be a joint family property. So that money is given for the joint
Therefore,
family
I have initiated the suit in respect of all the family members.
All of them are before the court.
No, because I have initiated separate suits. OS number that's why OS there are different OS numbers. The OS number 94, 95, 96.
What are those suits?
All suits are decreed in favor of the recovery of the money.
OS 95 is filed by the daughter for recovery of money, and
all suits are
96 is
decreed.
also filed for recovery of money by the granddaughter. Averments exactly same
Those suits.
They are stayed by this honorable court in other two WPs, which has been challenged by him
May I make
in respect of
all initially what happened? All the suits are
they are not
decreed
clubbed.
in.
They are not clubbed.
No, they are all pending on the file of the same court.
Yes.
All the suits are initially decreed. Subsequently, they have challenged in RFA. Only for the limited purpose for cross-examination of defendant, this honorable court remanded the matter with a specific direction to dispose of the same within a period of 6 months. Now 6 years have been lapsed. Subsequently, that order was challenged before the honorable apex.
Those two writ petitions will hear that also and pass an order.
One number, I don't remember.
Give those two numbers. List is writ petition.
This matter is posted today, and it is almost posted day to day. And
this is matter along with so and so on 19th January.
I request 22nd if possible, 19 to 20.
On 22nd till such time there shall be stay of all further proceedings.
In the same, my lords, in the preliminary hearing itself. In
In the same cap, under the same cap. Yes.
my name may be shown, my lords. Since, my lords, without issuance of notice, I have entered, my lords.
It's there, your name is there,
That's,
Chetan.
at least other note and that note may be, my lords, deleted.
Mr. So-and-so takes notice on behalf of respondent.
Please, my lords.
It's there, his name is there in the cause list.
Please.
Yes, next.
Chetan. Hearing on IA, seal number 7.
I am for the
Malik what?
Need
Muhammad Ali.
6 short accommodation was to file
Right.
statement of objection to the impleading application.
But impleading application has been came to file. Here the earlier president, now the annexure C is the impugned order. Your lordship kindly take annexure C.
I'll file a statement of objection to this impleading application. He has made certain allegation against me, and there are Kannada documents also that needs to be translated copies.
The request of friend counsel to the petitioner. This is matter after 3 weeks for filing his objections to the pleading petition.
Interim order may kindly be extended.
Interim order all granted is
Matter,
extended.
some urgency is there. 21st or
All 21st, it's not possible. We'll have it on 29.
please.
Yes.
Much obliged.
Seal number 8. NR Kuppelluru. Santosh K. Tirupati.
One is appeal by the insurance company, another by the claimants, my lord.
Hmm.
MFA number 103698, my lord, is by the insurance company challenging the finding of the tribunal on the point of negligence.
On the
That
point
there
of?
is a negligence,
Negligence.
my lord.
Hmm.
That there is a delay of 17 days in filing the appeal, my lord.
It's a case of death or injury.
Death, my lord.
Death case.
Let's see. Please come to the order.
My lord, the tribunal, my lord, while answering issue number 1, has held that, my lord, the rider of the motorcycle, my lord, ensured that the supplant was responsible for the cause of accident.
What is the evidence adduced by you, or what is the evidence on record to show that?
My lord, it is
deceased
not in dispute, my lord, the rider of our insured motorcycle was charge sheeted by the police for 279 and 304A, my lord, for causing the accident. But the very same contents of charge sheet indicate that, my lord, the owner of the motorcycle was also charge sheeted for handing over the vehicle to the person who had no valid DL at all. And, my lord, the said vehicle had no insurance coverage.
Will apply.
Therefore, my lord, the deceased who was riding the
No, no.
motorcycle
Even in that case, also principle of pay and recovery will apply.
was also, my lord,
Pay and recovery is granted in this.
no, that cannot be made applicable, my lord. In this case, I am seeking fixing some amount of contributory negligence against the deceased, my lord, who was driving the motorcycle.
No, for
Who was
that,
also,
there should be some evidence on record how the accident has happened, whether it is whose negligence is that. If you say that there is negligence on the part of the deceased, you should have adduced some evidence before the court. Without that, we cannot take. Only one thing that we can say is because it is he is not having a driving license, we'll say the principle of pay and recovery will apply. Question of fixing the contributory negligence will arise only if there is evidence on record.
the deceased, my lord, was the rider of another motorcycle.
Understood that.
Please.
I understood that.
Please.
So if you say deceased was responsible for this accident, the police records are against you.
No.
Have you now to say that there is contributory negligence, you should adduce evidence. That you have not adduced.
There is no such.
So then what about your compensation?
My lord, case of death, your lordship. The
What is the
accident-
age?
Age is 24 years, my lord.
What is the occupation?
Occupation is agriculturist, my lord.
How much according to you he is earning?
According to our pleading, my lord, we claimed 15,000 per month.
Which year is the accident?
2017, my lord. The tribunal has considered 10,010 rupees. Minimum wages.
250.
10,010 rupees.
We'll take 10,250.
250. And
Future prospects are
40% is considered, my lord.
how much it comes to?
And
It comes to 4,100. Is a bachelor?
bachelor, 50% to be deducted.
It It comes to 7,175 into 12. What is the multiplier?
18.
Who are the claimants?
Parents.
That is 44 into 2, 88, 36, 10,000. It comes to 16,83,800 against 15,93,500.
93,512.
And we'll apply the principle of pay and recover. You don't want pay and recover also.
It may not be applicable here, my lord, because he is the owner of the another motorcycle. Our insured motorcycle, my lord, had a valid DL. That is not an issue. My contention before this court, my lord, is to fix some amount of contributory negligence, my lord, reducing the.
That we can't,
So,
without any evidence. Yes. Please come. Agreed with award passed in MVC number 1612 of 2020, dated 8th May 2024. By so and so, both the claimant as well as insurance company are before this court. Insurance company's appeal is MFA number 103698 of 2024, and the claimant's appeal is MFA 100868 of 2025. So, in this, the docket order for the condonation of delay in MFA 103698, IN number 1024 is filed to condone the delay of 7 days condoned. Then in the appeal of the claimant, MFA number 100868 of 25, IA 1025 is filed to condone the delay of 187 days. They will not be entitled for interest for the set period. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the death of the deceased in the accident. The facts of the case are as follows. It is a case of the claimant that on 29/2017 at about 5 p.m., the son of the petitioner met with an accident. He along with his friend was proceeding on the motorcycle. The rider of the motorcycle, the rider of the opposite vehicle has dashed to the vehicle from the backside by riding it in a rash and negligent manner. It is a case that is working as an agriculturist and earning an amount of rupees 15,000 per month. The tribunal, when it comes to the issue of negligence, has held that the charge sheet indicates that the rider of the offending vehicle has dashed the deceased from backside. The deceased has sustained grievous fatal injuries on his body and died in the spot. And a close reading of the charge sheet indicates that the accident in question had occurred due to the rash and negligent riding of the rider of the offending two-wheeler. It is a contention of the insurance company that the accident in question has occurred due to the negligent riding of the two-wheeler by the deceased himself. However, material on record, such as a copy of the FIS and charge sheet, clearly indicate that the accident in question has occurred due to the rash and negligent riding of the rider of the offending two-wheeler. The court also observed that the claimant has to establish his case on the touchstone of preponderance of probability, and there cannot be a burden of proof beyond reasonable doubt. The court also gave a finding that there is no material to hold that the deceased has contributed to the accident, and accordingly held that the owner and the insurer of the offending vehicle are liable to pay the compensation. When it comes to the compensation, the court had granted an amount of rupees 15,93,512. as per the table given below. That's at paragraph, page number 15, extract the table. The learned counsel appearing for the insurance company submits that the court had failed to consider the contributory negligence on the part of the deceased. It is submitted that the deceased was not having a valid driving license. And in fact, a crime is registered against the owner of the said vehicle for handing over the vehicle to a person who is not having a driving license. It is submitted that court ought to have fixed the contributory negligence on the deceased. Next parallel, counsel appearing for the claimant submits that it is a case of the claimant that is earning 15,000 per month. The court had taken 10,100.
10,010 rupees.
10,010 rupees. It is submitted that at least as per the chart prepared by the Legal Services Authority, as this accident had taken place in the year 2017, 10,250 ought to have been taken. It is submitted that on that count, the enhancement, the compensation needs to be enhanced. Next para. Having heard the counsels on either side, peruse the material on record. First, coming to the contention of the insurance company with regard to the contributory negligence on the part of the deceased is concerned, when the burden lies on the party who asserts or who claims contributory negligence. It is a case of the insurance company, there is a contributory negligence. The evidence on record clearly reveals that no evidence is adduced by the insurance company in that regard. The tribunal had rightly held that in a motor accident claim, the burden is only on the touchstone of preponderance of probability, but not on beyond reasonable doubt. In those circumstances, this court do not find any reasons to interfere with the well-considered order passed by the tribunal on the ground of liability. Then coming to the quantum, it is a case of the claimant that the claimant is earning an amount, the deceased was earning an amount of rupees 50,000. No doubt, no evidence is adduced before the court. However, considering the chart prepared by the Legal Services Authority, as this accident has happened in the year 2017, this court is taking the income at 10,250. The deceased was aged about 24 years. Future prospects at 40% would come to 4,100. That is, his income would be 14,350. As is a bachelor of 50% has to be deducted towards the personal expenses. That is 7,175 into 12 into 18 is 15,49,800 under the head of loss of dependency. Loss of consortium 44 into 2, 88,000. Loss of towards funeral expenses 36,000. In the light of the law laid down in make allowances so and so towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 16,83,800. Accordingly, the appeal filed by the insurance company MFA number 103698 of 2024 is dismissed. MFA number 100868 of 2025 filed by the claimant is partly allowed by enhancing the compensation from 15,93,502 to 16,83,800. The enhanced amount shall carry 6% interest. The amount in deposit shall be forthwith transferred to the trial court.
Obliged. Please.
Yes, next.
Seal number 9. A.S. Patil.
None appears. This is matter in the month of March. Don't extend the interim order if it is there also. Yes, next.
Seal number 10. Surabhi Ravindra Kulkarni.
For the appellant, my lords, beneficiaries appeal, my lords. In second matter, my lord, there is a stay, my lord. This honorable court has granted stay in 10.1. In 10, my lords, there is a delay, my lord, of 51 days, my lord. Notice may kindly be issued. In first matter, my lord, in serial number 10, there is a delay, my lord, of 51 days.
What about this
beneficiary? This is beneficiary appeal, your lordship. We are for the state, and acquisition is by the state, your lordship, and handed over to the beneficiary. So notice has to go. There is a delay, your lordship. It is a new respondent.
Yes. What about
in 10.1, my lords? Notice is served, my lord, upon R2, and my lord, R1, my lord, is government, my lords. Government may kindly be directed to accept notice.
So and so is directed to take notice on behalf of R1.
Please.
Yes.
Seal number 11. Rishas Maigur.
My lords, it's a claimant's bill for enhancement of compensation, my lords.
What is this delay of 4,041 days?
My lords, the appellants were deceased was the only son of the appellants, my lords. And since they are the age old and
Appearing?
Respond number 1.
What do you say?
It's a long. Patil. KR Patil.
What is that?
KR Patil. Respond number 1.
Ms. KR Patil is, you have filed wakalat.
Yes, ma'am.
As far it is submitted that Ms. KR so and so has filed the wakalat. Yes. You want to file your
Yes, sir.
and seeks time for filing objections to I number 1 of 2025. This is matter after 2 weeks.
my lords, kindly one date will be given, my lords.
This is matter on not 2 weeks. This is matter on 2nd of February.
Please, my
Yes, 12.
Seal number 12. Please. Ita KM.
I number
Appear
1
for
of
the
2023
petitioner.
is filed.
Paper publication is filed.
Is filed for seeking substitute service of notice on which respondent?
Our respondent to you, Lordship.
Respondent number 2. Accordingly, I number 1 is allowed by permitting the petitioner so and so to take out substitute service of notice on so and so in so and so newspaper,
Karnataka Times, Gokak edition.
mentioning the date of hearing.
Please,
Yes, on or before so and so.
please.
Okay.
Seal number 13. Namantar Latur.
First appeal is filed by claimant and connected is one filed by the insurance company.
Lord, insofar as the first appeal is concerned, Lord, the copy of the appeal memo is not served on me. I'll collect and
Then
file my
counsel
statement
the
of
appellant to
objections.
serve the copy of the appeal memo on the counsel appearing for the respondent. What about the second one? You have served on him?
Yes, I
Yes.
served.
Yes, list these matters in the month of February. AS 14.
Seal number 14. NR Kuppeluru.
Please, my lord, the appeal by the insurance company challenging quantum, my lord, that there is a delay of 34.
What is granted?
My lord, 54 lakhs 58,900 is 54 lakh 58,900 is granted, my lord. Appeal challenging quantum, my lord, that
It's a case of death.
the fresh matter, my lord, the case of
I
death.
understand.
Please.
So what is the admitted amount?
Admitted amount, my lord, 25 lakhs, my lord. 25 to 30 lakhs.
How
The
it
tribunal,
has
my lord,
become half of it?
The tribunal, my lord, has taken 10,000 as an additional income from agriculture source, my lord, only on the basis that they have produced some RTC extracts. In addition to the notional income,
What is his occupation?
agriculture, my lord.
Which year is the accident?
That is 2022, my lord. The income
It is 14,750.
14,500. But in addition to that, my lord, 14,500, tribunal has considered
What is the
additional
age?
28 years. Even if that is not considered 10,000 additional, madam, excess amount comes to amount 14
That's why
lakhs.
I'm just calculating it.
14 lakhs, madam.
So it comes to 2650. How many are the dependents?
There are 5 minutes.
What is the multiplier?
Multiplier of 17.
That itself will come to 31 lakh 59,450. How can you say it is 24 lakhs admitted amount? As per your own.
Subject to deposit 50%, my lord, that can be.
No. 31 lakh 59,450. You said 5 are the dependents. Almost 34 lakhs, as it is, it comes. Deposit that amount.
34 minutes.
And they'll be at liberty to withdraw as per the award passed by the tribunal, as per the conditions laid down in the award.
Please.
The land counsel appearing for the insurance company submits that the insurance company is before this court on the ground of quantum, questioning the quantum. It is submitted that without any evidence, the court had taken 10,000 extra basing on the RTC extracts, which is on the higher side, and granted compensation of an amount of rupees 54 lakhs and odd. Next paragraph. Considering the submission of the land counsel for the appellant, even if that amount is taken as 14,750, as this accident has taken place in the year 2022, along with the other conventional heads, the amount would almost comes to 34 lakhs. In that view of the matter, they shall be stay of all further proceedings on the condition that the appellant insurance company shall deposit an amount of rupees 34 lakhs within a period of 4 weeks from the date of receipt of the copy of the order.
With interest.
With interest within 4 weeks from the date of receipt of the copy of the order. The respondents are on such deposit. The respondents are at liberty to withdraw the amount as per the conditions laid down in the award. Notice to the respondent.
Issue. Number 15.
Interruption. Serial number 12 stay may be extended. Serial number 12 stay may be extended. In that it is stay is there. Paper publication I have filed, stay may be extended.
No. Question of stay now at this now will not arise. Yes.
Bill number 15, Sanjay.
Please. Claimant's appeal injury case, delay may be condoned, may be referred to Lok Adalat.
I number 1 of 2025 is filed to condone the delay of 170 days, condone on condition, at the request of the parties, at the request of land counsel, the petitioner. This is matter before the Lok Adalat. Next 16.
Seal number 16. R.R. Manik.
Notice to the respondent.
My lord, I am for the insurance company, my lord. I am seeking stay, your lordship. I am seeking stay also.
On what ground you are before this court?
My lord, there was no insurance at all, my lord. I have laid evidence also.
Huh?
But there was no, the vehicle which caused the accident, my lord, which was not having valid insurance at the time of accident, my lord. I laid evidence to that effect, but still then, my lord, the tribunal has fastened liability on the insurance company.
Has no valid insurance policy as on the day, but still the tribunal has held the insurance company liable to pay the compensation. Hence, they shall be stay of all further proceeding, 50%, 4 weeks.
Please, ma'am.
Number 7, no permission to withdraw. Yes, next.
Agmat.
I appear for the appellant insurance company, my lords. There is a delay of 14 days, my lords.
Yes. Notice is already served.
Yes, my lords. None
I
of them.
number 2 of 25 is filed to condone the delay of 7 days in filing. Condone for the reason stated. Admit post for fine hearing, call for the TCR. No admit. Call for the TCR.
TCR.
Yes, 19.
Seal
They
number
may be
18.
extended, my lords.
Oh, this is 17 or 18?
17.
What is
my
called
lords.
17? Oh, then it's 14 days. Condone, admit, fine hearing, TCR. Then 18.
Serial number 18.
There's another appeal filed by the claimant.
Claimant has filed appeal. It may be connected and posted along.
Along with so and so. Yes, next. And the registry is directed to call for
Copy
TCR.
of that, my TCR. I may be permitted.
Sharmila Patil may be directed to take. I'll serve the copy.
No, that without that petition being here, how can I say that so and so will take notice?
Connect. It should only be connected. I should get the copy of the appeal, my lords.
Yes. The so and so, the counsel for the respondent shall serve the copy of the appeal memo on the counsel. Yes, 19.
Bill number 19.
Lords, appearing for the petitioner, my lords. Lords, there is
Number
a
19.
necessary translating copy has to be annexed, my lords.
Huh?
Necessary translating copy has to be annexed. Kindly post this on Monday, my
On
lords.
or not?
My lords. Lords, kindly post this matter on Monday, sir. The necessary translating copy has to be annexed, my lords.
My lords.
My colleague is appearing through
At
VC.
request of non-counsel of the petition, this is petition on 12/1/2026.
19, my lords, please.
How many times you will list the matters? Please understand. List this matter in the month of February.
My lords, my colleague is appearing through VC.
My lords, I appear for the petitioner, my lords.
Yes.
My lords, my lords, the matter was listed on 8th, my lords. My lords, I had asked for filing of translated copies, my lords. only 4 or 5 pages of translated copy are pending, my lords. Apart from that, everything else is already
Yes,
translated, my
this
lords.
is matter on 29th of February. Yes, next.
My lords,
Sir,
date is on 19th, my lords, because the matter is held daily, my lords, in the trial court, my lords.
You should have filed it by this time then.
My lords,
18.
pardon me, my lords, it was only 4 days.
18. Yes, next.
19th, my lords. Interim order may be extended, my lords. My lords, pardon me. My lords, on the last date, my lords, the interim order was not extended, my lords. Interim order date.
23rd of January. Interim order earlier granted is extended.
Serial number 20, I appear for petition.
Number 20.
Section 14 under the Surface Act is called in question. Let's, after hearing the matter for some time, this on the previous bench had directed me to file an affidavit undertaking, saying that within certain period I would clear my entire due, Millards.
What is the outstanding amount as of now?
Outstanding due as on the date of filing of this petition was around 6 crore, Millards.
Who appears with the respondent?
Uh,
Yes, Mr.
Satyanangri.
Petitioner, my lord.
What is
I
outstanding as on today?
My lord, as on my lord, 29th of November, my lord, there is a 3 crore 76 lakhs, my lord. My lord, it is a 5th round of litigation, my lord. The petitioner is
1
already.
minute. So when are you going to pay 3 lakhs, 3 crores 76 lakhs?
Millards, we have filed an affidavit. We say that, Millards, till the month of February, we'll pay each month 20 lakhs because, Millards, it's a school. So by the end of the March, Millards, before 31st of March, we'll clear off the entire due because, Millards, admission starts in the month of March for the schools. So we filed an affidavit. We sought for 3 months of time. They have agreed in their objection for 2 months.
When is that affidavit?
Affidavit filed by the petitioner is dated 4th December 2025.
Where do you get that?
Affidavit is filed after the petition is filed.
Yes, Mr. We'll consider it.
My lord, what happened, my lord? They are continuously, my lord. He is not paying the loan, my lord. And my lord, it is a loan account is NPA, my lord, in the year of 2022, my lord.
We'll make it very clear. We'll make it very clear. If this order is not complied with by the petitioner, no further writ petitions will be entertained.
And my lord, even my lord, they are approached the Supreme Court also, my lord. There also they are taken made a submission, my lord. There is also, my lord, they are not paid the amount, my lord.
That's after the interim order by this honorable court. We have strictly complied the interim order. After that, Millards, this
How much you
affidavit
have
was,
paid after the interim order?
interim order was granted subject to payment of 1 crore rupees, Millards. That is paid. After that, Millards, we had filed an affidavit stating that till the month of February, we would deposit 20 lakh rupees. In the month of December, Millards, we have deposited 20 lakhs. So by the end of March, Millards will.
Where do you get that?
Millards, affidavit dated 4th December. Para, Millards, page 3. It starts from para 5, Millards.
No, what you have opened as is a caveat.
May I pass on the affidavit, Millards?
It's here. Which paragraph?
More than 6 crore is already paid. What remains is around.
What is your undertaking? That I want to see.
Yes.
Which paragraph?
Paragraph 6, 7 and 8 minutes. 7, the petitioners hereby solemnly undertake before this honorable court that they shall pay a sum of rupees 20 lakh rupees every month for the month of December, January and
Have you paid
February.
this December 20
We have
lakhs?
paid. We have paid 20 lakh rupees. January, Millards, by the end of this month, we shall pay 20 lakhs. By the end of March, Millards, we shall clear the entire due of the bank, Millards.
Please come. The present writ petition is filed. Seeking the following prayer. Extract the prayer. It is, the petition is a society who has established educational institutions They avail the loan from the respondent bank. It is stated that during the COVID-19 pandemic, they have suffered huge losses and setbacks. And they were not in a position to pay the amounts. And also approached the bank requesting them to restructure the loan. The bank, without considering the request of the petitioner, has classified the account as NPA on 29/8/2023. And a demand notice was issued under Section 13(2) of the Surface Act on 21/12/2023, demanding the petitioner to pay an amount of rupees 6 crores 28 lakh 50,000. Then a petition notice was issued on 3/4/2024 to recover the overdue amount. And the sale notice was issued on 15/6/2024, undertaking the symbolic portion of the scheduled property. It is stated that earlier they have filed WP number 102-514 of 2024, challenging the possession notice dated 3/4/2024. And an interim order was granted on 25/4/2024, subject to the condition that the petitioner shall deposit 50 lakhs within a period of 2 weeks and another sum of rupees 15 lakhs within a period of 4 weeks from the date of the interim order. As the petitioners could not pay the amount, the writ petition came to be dismissed by order dated 23/7/2024. Thereafter, the bank has filed a criminal miscellaneous number 93 of 2024 before the first additional senior civil judge and CJM Dharwad under Section 14 of the Surface Act, and the same was allowed by order dated 17/4/2025. It is stated that the petitions have already approached the Debt Recovery Tribunal by filing essay number 324 of 2024. And they are not pursuing the same as they are negotiating with the bank. The learned counsel appearing for the petitioner submits that an order was passed on 15/10/2025. Pursuant to the said order, they have paid 1 crore. Further, they have also filed an undertaking affidavit that in the month of December, they will pay 20 lakhs. January, February, they'll be paying 20 lakhs per month. And in the month by 31st of March, they would clear the entire loan amount. It is submitted that the school admissions will start in the month of March and they would be able to have the resources to repay the amount. Hence, the undertaking affidavit may be taken on record and the writ petition may be disposed of. When counsel appearing for the bank submits that the petitioner is coming up with one writ petition after the other, even they have carried the matter to the Honorable Apex Court. It is submitted that they have also approached the DRT. And only to protract the proceedings, they are coming up with these kind of applications. And a huge amount is outstanding as on today. It is submitted that as a petition as an alternative remedy, and in the light of the settled law, the writ petition is not maintainable before this court. And the petitioner, who is a chronic defaulter, is not entitled for any relief from this court.
My lord, even another ground, my lord, it is a second writ petition, my lord, same prayer, my lord.
It is submitted that it's a second writ petition of the same prayer. According to you, it's acceptable if they pay within 2 months. Shall I record that?
My lord, no, my lord.
They have stated in their
If they are not
objections.
ready to pay, my lord, if they are not ready to pay the, my lord.
No, you said so in your objection that if they pay within 2 months, the bank is okay with that. Shall I record it?
Yes, my lord, in the objection, my lord.
Next paragraph. In counsel submits that in the objections, they have stated that if the petitioner is ready to pay the amount within 2 months, the bank has no objection. Next para. Having heard the counsels on either side, there is a material non-record. First, why the petitioner has come before this court filing a writ petition when the proceedings are initiated by the initiated by the bank under the Surface Act, and what are the compelling reasons that this writ petition has to be entertained by this court when the petitioner has an effective alternative remedy has not been stated. The petitioner is a society running educational institutions. The petitioner has filed earlier writ petition, obtained an order, failed to comply with the same, and this court had dismissed the said writ petition. Now this is the second writ petition.
It is the third writ petition.
As rightly, this is third writ petition, and as rightly argued by the land counsel appearing for the petitioner, for the respondent bank, such a writ petition cannot be entertained by this court in the light of the alternative remedy that is available to the petitioner, and also looking at the subsequent conduct, looking at the conduct of the writ petitioner. However, considering the fact that already an interim order is passed by a coordinate bench of this court, that order is complied with, the petitioner has filed an undertaking affidavit that they will pay the entire amount, clear the entire amount by 31st of March, balancing the interests of both the parties. This court deems it appropriate to dispose of the writ petition as per the following order. Number 1, the petitioner shall pay an amount of rupees as per the undertaking, an amount of rupees 20 lakhs by end of January, 20 lakhs by end of February, and by 31st of March, whatever is the outstanding amount shall be cleared. Number 2, the bank shall communicate to the petitioner exactly what is the outstanding amount as on 31st by 31st March 2026. 3, if the petitioner fails to the petitioner fails to pay the amount, the respondent bank is at liberty to take further steps under the Surface Act. Number 4, the petitioner yes.
Great.
My lord, one submission, my lord. My lord, we are already taken the possession, my lord, insofar the house properties, my lord. After the payment of all the dues, my lord, we will restore the possession, my lord.
If entire amounts are paid, once the entire amounts are paid, after the by 31st of March, by 30th of March or 30th or whatever the date, March, then the bank shall redeliver the portion of the property.
Let's, insofar as school is concerned, possession was handed over to run the school.
Whatever the remaining thing.
Yes. Let's not to precipitate the matter. Insofar as school is concerned, let's.
After 31st, my lord, we will precipitate, my lord.
You are at liberty to do whatever you want to do.
Yes, yes, my lord.
Great.
Yes.
Seal number 21.
Please, madam.
Prasad Patil.
Yes.
My lord, the petitioners are the municipal authority, my lord. The respondent, who is the owner of CTS number 1134 and 1135, my lord.
What is the suit for?
Suit for permanent injunction was filed by the respondent against the municipal authority.
Here is the suit.
The suit in the year of 2009, my lord.
Filed by the municipality.
Filed by the respondent.
My lord. Respondent against.
Against the municipality.
What
authority.
happened to the suit?
My lord, the respondent who has illegally encroached the public road, my lord. Therefore, the municipal authority, they have issued a notice to the respondent.
No, what happened to the suit?
That the suit was came to be dismissed, my lord.
Dismissed.
Dismissed.
And then?
And thereafter, he filed a regular appeal 55/2011 before the senior civil judge, my lord. And wherein the municipal authority and the respondent, they have together filed a compromise petition
compromise petition, and the respondent, he has agreed to remove the encroached area in the public road, my lord. And the municipal authority, they have agreed to allow 2 plots to the respondent, and they have filed a compromise petition, and the compromise petition was accepted by the trial court, and decree was passed on. And thereafter, that decree was drawn in the year of 2017, my lord. And thereafter, he kept memo the same. In the year of 2023, he filed an execution petition for allotment of 3 plots. The compromise entered between both the parties for allotment of 2 plots, my lord. But he filed an execution petition for allotment of 3 plots. In the year of 2017, immediately after passing a decree, the municipal authority, they have allotted the plots to the mother of this respondent and the daughter-in-law of the respondent. 2 plots were allotted as per the government scheme known as Vajpayee Nagar Housing Society, wherein the
No, as per the compromise, to whom you have to allot?
respondent.
Then why did you allot it to
my
somebody
lord,
else?
since Vajpayee housing site allotment, the plots have to be allotted a female member of the family, my lord. Therefore, with the consent of this respondent only, we have allotted the plots to the mother of this respondent and the daughter-in-law of the respondent, my lord.
Then what happened?
And since from 2017, he kept memo the same. In the year of 2023, after lapse of 7 years, he filed an execution petition before the senior division. And my lord, the senior civil judge, he is having no jurisdiction to entertain the very execution petition as per section 37 of the civil procedure code, my lord. Since the suit was filed before the junior division, therefore they have to file an execution petition before the junior division only, and the execution petition was filed before the senior division. And the honorable senior civil judge, without verifying the compromise decree passed in RA number 55 2017, that he agreed to allot 2 plots, but they have filed an execution petition for allotment of 3 plots.
Now please come to the compromise decree dated.
My lord,
My lord,
page number 36 of the writ petition, annexure B, my lord.
On 11/3/2017, my lords. 11/3/2017, my lord.
11/3/2017.
Yes, my lord.
So where do you get that plot?
My lord, 36 page number clause 1, my lord.
Please read that.
ಮೇಲ್ಮನವಿದಾರನಿಗೆ ಒಂದನೇ ಎದುರುಗಾರನು ಕುಂದಗೋಳ ನಗರದಲ್ಲಿ ಬರುವ ಮಾನಪ್ಪನ ಮಠದ ಹತ್ತಿರ ಇರುವ ಪ್ಲಾಟ್ ಅನ್ನು ನೀಡಿರುತ್ತಾರೆ ಅಂತ ಮೇಲ್ಮನವಿದಾರನು ಹಾಗೂ ಒಂದನೇ ಎದುರುಗಾರನು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ 1 ಪ್ಲಾಟ್ ಪರ್ಟೈನಿಂಗ್ ಟು. ಸೆಕೆಂಡ್ ಮೈ ಲಾರ್ಡ್, ಮೇಲ್ಮನವಿದಾರನಿಗೆ ಒಂದನೇ ಎದುರುಗಾರನು 2 ಪ್ಲಾಟ್ಗಳನ್ನು ನೀಡಲು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾನೆ ಅಂತ ಮೇಲ್ಮನವಿದಾರನು ಒಂದನೇ ಎದುರುಗಾರನಿಗೆ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. So the question is with regard to 3 plots, my lord. So far as clause 1 is concerned, I accept that 1 plot has been allotted, but that plot never came to be handed over to me.
Now according to you, it is 2 plots or
3 plots. 3 plots.
No, my lords. By reading the clause number 1, my lords, it is very clear the 2 plots were agreed to allowed in Manappana, near Manappana Mata. And as per clause number 2, the present petitioner, they have agreed to allow 2 plots to the near to Manappana Mata. And the clause 1 is, it shows that already the plots were allotted in the name of her, his mother, and in the name of daughter-in-law of the respondent, my lord. And the plots were allotted in the year of 2017, my lord. The annexure.
No, I am only trying to understand this compromise decree.
My lord, it says,
my lord,
number 1, that is referring to 1 plot.
Please.
What is clause number 2 saying?
My lord, ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಒಂದನೇ ಎದುರುಗಾರ ಕುಂದಗೋಳ ತಾಲೂಕು ಕುಂದಗೋಳ ನಗರದಲ್ಲಿ ಬರುವ ಮಾನಪ್ಪನ ಮಠದ ಹತ್ತಿರ ಇರುವ ಪ್ಲಾಟ್ ಅನ್ನು ನೀಡಿರುತ್ತಾರೆ ಅಂತ ಮೇಲ್ಮನವಿದಾರನು ಹಾಗೂ ಒಂದನೇ ಎದುರುದಾರನು my lord, that the petitioner they have agreed to allow the plots to the respondent near Manappana Mata.
No, it doesn't refer to the number of the plots.
That referred in clause number 2, my lord, wherein 2 plots were agreed to allow near to Manappana Mata. Now he is interpreting that they have agreed to allow 3 plots to the respondent.
Clause number 1 refers to 1 plot.
No,
Clause
my lord.
number 2 refers to
No, the clause number 1, it is a place where the plots were allotted.
This particular page, find the translation only for these 2 clauses.
my lord, may I just make a submission? Clause 1 says, as my learned brother will accept, I made a submission that one plot has been allotted. Second clause says that they undertake to allow 2 other plots. So now they are saying one plots are been allotted. So my submission before the court is no plots are been allotted. Kindly turn to page number 8 of my statement of objection. The TMC give
No,
under
first of all, this has to be cleared whether it is 2 plots or 3
no,
plots.
no, my lord. They have given in RTI. They have given, if TMC authority has given, saying that no plot has been allotted in pursuant to the decree.
I'm asking,
Please.
as per the compromise decree, it is 2 plots or 3 plots. First is, that's for the first dispute.
Please.
Second is what they have executed is the next step.
Please.
So for the first step, he says it's only as per this compromise decree,
Please.
2 plots.
Please,
You are saying 3 plots,
please.
which is correct.
My lord, 3 plots, because first clause says that 1 plot is already been allotted.
It's already allotted.
Allotted. I accepted, but that was not confirmed. So the no land was allotted to me. That was taken away back because of some miscellaneous work that was carried out by the TMC.
So first of all, we'll understand what about his interpretation of both
My
of
lord,
you
once.
in a plain language that is employed in that.
May I make one submission, my lord? I have filed an RTI exhibit endorsement given by the TMC saying that no land has been allotted to me pursuant to the compromise decree.
Going back to that, I'm
Please,
saying,
please.
let me understand this.
Please.
Understand this compromise deed.
Please.
So according to you, clause 1 says already 1 plot is
Please.
allotted.
Please.
Clause 2 says 2 plots are yet to be allotted.
Please.
Is it correct or not?
Please.
My lord,
This is the translation.
In clause 1, the place was mentioned where the plot has to be allotted.
The place.
Yes, ma'am.
It says, clause 1 says,
Yes.
1 plot is already allotted.
Yes. Yes, ma'am.
Correct or not?
Yes, ma'am.
Clause 2 says you have to allot 2 plots.
2 plots.
So all put together, it becomes 3.
Please.
Yeah.
Provided you have allotted 1 already.
Two.
It will be
We have.
Not, no, if you say that it is not allotted, why did you accept such a compromise?
Well, it so happened, the execution petition, if the order sheet is looked for two long years, they went on seeking time for compromises. So then it so happened like morning of the TMC authorities, one minute.
Compromise decree,
Please, I'm answering this.
Binding on you.
No, one submission. On the morning of that order date, the authorities took me to the place. They said that this land will be allotted to me. This will be given to me. So I agreed and I came it and signed it. My lord, subsequently, there's some water pipeline was to be carried out. Then they made it clear that no, it cannot be allotted because the pipeline will be affected. So we'll alternatively.
So now please show to the court, where are the 3 plots allotted to him?
Please.
My lord, as per annexure D and E, my lord.
Page number?
Running page number 42, my lord. 42 and 43. You know, 1 plot was allotted to the mother of this respondent, and another plot that is annexure E, which was allotted to the.
Please, my lord. Yes. No, that is nothing to do with me. It was allotted in general public, like any other social welfare projects, to that. So far as the first clause, as your lordship read, my lord, that plot is not available. Let them show that they have allotted to me that land, which I have agreed. What your lordship asked me, that the land is already been allotted. Let them show the document if they have allotted me that document.
My lord,
if they have, as they say that they have already complied as per the decree, let them show that they have already allotted me near that Manapanamata. That plot is not yet been executed. That's exactly what my submission is. And so far as the 2 other plots are concerned, like any other women, my lord, in the town, because it's allotted to mother and the daughter, my lord, not to me. And they have given an endorsement that pursuant to the compromise decree.
It's a compromise decree.
Yes, ma'am.
Compromise decree.
Yes, ma'am.
You have to, you are bound by the terms and conditions of the compromise.
My lord.
Now, in the compromise, you have undertaken to allot the land to him.
Yes, ma'am.
Not to any other family member.
My lord, since there was a difficulty.
That kind of an interpretation we cannot.
My lord, for the benefit of the family, any one of the person,
That's not the purpose of the compromise.
My lord.
If that is the case, you would have mentioned in the compromise that now, as per the scheme, we can allot 2 plots to the family members, but not to the respondent. But you didn't say so.
My lord, as per the Vajpayee scheme, my lord, housing scheme, the property has to be allowed to the female member.
Some CPC and a compromise decree and the procedure.
Yes, ma'am.
We can't generalize.
As per his consent only, the plots were allotted. My lord,
Where do you get that? Where is his consent? Where did you obtain? Where did you say that in partition to the compromise decree, we are allotting so and so?
My lord, the decree was passed on 21/3/2017, and the plots were allotted on 21/7/2017. Within the 3 months, we have allotted the plots to the,
Can't be the reason.
since
And you're saying that there is his consent is there. Where is his consent?
as per oral consent of the respondent, that is the
You
reason.
can't consider all this, Mr. Counsel. We
Well,
can't
one submission.
You're bound by, your municipality is not a like a illiterate, you can't behave like that.
My lord, since
From one submission,
my lord, since the two plots were not allotted to the same family member, since the plots were allotted to mother and daughter of, that has to be considered, my lord. Why? Because the two plots were allotted to the family member of this respondent. It is only because to comply the decree passed by the senior civil judge. Therefore, with the consent of this respondent only, we have allotted the plots to the mother and daughters of.
Go to the court.
That oral consent, my lord.
We can't look at something, we can't infer something. We can only look at when there is a compromise decree, you have to comply with it. And the complaint should be placed before the court. And how do you, according to you, where is the complaints? And all this, his consent and all, nothing on record.
Lord, since the decree was passed in the year of 2017, my lord, he kept memo over the same till 2023. It shows that, my lord, if at all he has not, if the petitioner has not complied the decree, my lords, he could have filed an application earlier to.
That's why the law of limitation is there.
Yes, ma'am.
Till what years, how many years are available for him for filing an execution? He has filed within the same. And there are several cases where the execution will be filed at a later point of time because it permits them for 12 years.
My another submission, my lord, under sections 37 of Civil Procedure Code, the execution petition has to
What
be
do you say on
filed
that?
before the
One more
junior
submission,
division, my lord.
my lord, one submission. The contents of the petition are absolutely in contrast with the submission before the trial court. For 2 long years, they made a submission seeking time to comply. This is a specific observation. For 2 long, every day they have taken the time saying that we will comply.
But ultimately, no parties cannot confer.
My lord, president of the team,
jurisdiction on the court.
my lord, the president of the TMC was present, officer was present, advocate was present. They made a submission.
Do you accept the proposition that parties cannot confer jurisdiction on the court?
My lord,
An order that is passed by a court without jurisdiction is a nullity.
please. No. The short time saying that compliance, it means to say that they are.
Let us accept that. Let us
Please,
accept
please,
they have
please.
done it. Still, I'm asking whether the parties can confer jurisdiction on the court which has no jurisdiction.
No.
We'll set aside this order on that and we will remand the matter to the say so and so without going into the merits of the matter. The present writ petition is filed, agreed with the orders passed by the civil judge and JMFC. What is her name?
Kundgol.
Kungol in I number 2, in EP number, in execution number 9/23, dated 17/10/2025. The municipality is the, which municipality is this?
Kundgol municipality.
Kungol municipality is the petitioner before this court. The respondent herein has filed a suit, that is OS number
26/2009.
Number 26 of 2009 before the civil judge and JMFC Kungol, and the same was dismissed by judgment dated 17/2/2016. Then the respondent herein has preferred an appeal, that is RA number 55 of 2016 before the senior civil judge and JMFC Kungol, that is, and the same was that was compromised by between the parties, and they filed a compromise memo, and it was compromised by and a compromise judgment and decree was passed on 11/3/2017. As per the same, already one plot is allotted to the respondent and 2 more plots they will allot to the respondent. It is a case of the municipality that as per the compromise, they have allotted 1 plot by the date of the compromise and 2 plots to the wife and daughter-in-law.
Wife and
Mother and daughter.
Daughter-in-law of the respondent. And the petitioner, the respondent without any basis has filed the execution petition. Learned counsel appearing for the respondent submits that the municipality, as per the compromise deed, has not allotted any of the plots. And the two plots which they are referring to, which are allotted to the wife, to the mother and the daughter-in-law, have no nexus with the compromise, and they have done it in the schemes as provided by the government. It is submitted that by the government. Next parallel, and counsel appearing for the petitioner submits that the judgment and decree is passed by the junior civil judge.
Yes.
And now the EP is filed before the senior division, and he has no jurisdiction to entertain the execution petition. It is submitted that after obtaining the consent of the respondent, they have allotted the two plots in favor of the mother and the daughter-in-law, the respondent. It is submitted that the order impugned needs to be set aside on both the grounds that one, that they have complied with the compromise decree, and number two, the court has no jurisdiction which has passed this decree. Next paragraph. When counsel appearing for the respondent decree holder submits that petitioner, the respondent decree holder has not given any consent as stated by the petitioner judgment debtor, and the properties that are allotted, the two plots, have nothing to do with the compromise decree. As per the compromise decree, 3 plots are to be allotted to the decree holder, and the municipality has failed to do the same. It is submitted that at this stage, the judgment debtor cannot raise the issue of jurisdiction when they have submitted themselves to jurisdiction of the court, and before the court they have submitted that they will comply with the order of the court. As such, that ground is not available to the judgment debtor, and the executing court, considering all these issues, has passed a reasoned order and no interference is called for. Next paragraph. Having heard the counsels on either side, peruse the material on record. First, the ground that is raised by the judgment debtor, that the court has no jurisdiction, as the order that is original, the compromise decree is entered before the senior division, and now the execution is also filed before the senior division. The submission of the land counsel for the decree holder that the petitioner has submitted to the jurisdiction of the court. As far as that aspect is concerned, this court is not able to appreciate the submission. The parties cannot confer jurisdiction on the courts, and any order that is passed by a court which is not having a jurisdiction is a nullity, which can be questioned at any point of time. In that view of the matter, this court is of the considered view that
Senior civil judge.
Senior
civil judge.
The senior civil judge and JMFC Kungol as not having jurisdiction to entertain this execution petition. Next issue that is pertaining to the order that is passed. And in that regard, this court is not inclined to go into that aspect, as the order itself is going to be set aside by this court. As the court is lacking jurisdiction, it is always open to the municipality to raise all the grounds, to both the parties to raise all the grounds before the junior division court,
Yes.
to whom the jurisdiction lies. Accordingly,
The senior civil judge may please be directed to transfer the execution petition before the junior division.
Accordingly, the appeal, the petition is allowed by setting aside the order passed in so and so by so and so. The so and senior civil judge and JMFC Kungol is directed to transfer the EP to the
Civil judge and JMFC Kundugol, my lord.
to the junior civil judge and JMFC.
Yes, madam.
FC Kungol.
Yes, ma'am.
And the executing court shall consider this application as expeditiously as possible, but not later than 2 months.
Please.
Please.
he shall transfer this case within a period of 15 days from the date of receipt of the copy of the order. From that time, 2 months.
Please.
Seal number 22 adjourn. Seal number 23. M.R. Hiremath.
My lord, the respondent.
SCGP.
My lord.
One minute, what, let us hear
My
what
lord,
you're saying.
my lord, the respondent illegally approved the list of committee management members against the interim stay order granted by this honorable court and also against the orders of the trial court in OS number 243 of 2021 on IA, Your Honor. And the claim of the persons who have been inducted by the respondent number 1 in the committee members has been rejected by the trial court in the suit, Your Honor. And against that suit, they prepared the
No, they have filed the vacate stay petition.
My lord's advocate on record is held up in the third quota number 3, my lord. He's arguing the matter.
25 for impleading R2 to R6. You filed the impleading petition.
no, sir. They have not furnished any copy to me, and they are not necessary party.
Then counsel for the respondent shall serve the copy of IA number 3 on the counsel for the petitioner. This is matter next week.
Till then, kindly extend grant the interim stay order, my lord.
Is it granted till now?
No, not granted, Your
Let
Honor.
it come next week. Yes, next.
So kindly connect the matter, until pending matter, Your Honor.
Along with so and so.
WP number 10108925.
Yes, give that. Yes, next.
Seal number 24. Pass over.
Which one pass over?
Seal number 24.
Which is the connected? Please come.
In fact, I moved the matter. I am for the claimant.
Mallikarson.
Next week, my lord, I will go through. There are 2 charge sheet, my lord. Both the drivers are equally charge sheeted.
No, which matter?
24.
25, my lord.
No, he's on 24.
Please. No, 24 is my lord's, it along with that WP.
Along with?
Tender matters, my lord's.
Oh, it is at 62 and 63. Yes. Yes, 25?
25 minutes. In fact, I moved the matter.
Week I will claim.
What happened? I moved the matter only my lord for this reason. Stay was granted. They are challenging my lord's 50% of the my lord's award has to be my lord's on the respondent number 3. Contributory negligency they are pleading. 50% is my lord's they supposed to that's a deposit that has to be released. Without my lord's the.
In this case, what has the tribunal, even after having observed that, my lord, the owner of the motorcycle has violated the conditions, terms and conditions of the policy. Insurance company is at liberty to get pay and recover. But in the relevant portion of the order, my lord, that it has not.
That we can anyhow incorporate while allowing this, while passing orders on the MFA. Now, what is your objection for withdrawal of the money by the claimant?
No, they are not deposited. In fact,
Why?
stay was granted. Stay was granted without there being condition. That is what I am pleading. Without
can it
there.
be you that?
27/20/22 stay was granted. Maybe minutes by oversight. I am not Miller seriously disputing.
Deposited, my lord.
27/20 deposit.
4,93,771, my lord, were deposited. In compliance of stay order.
I'm sorry, Miller. It is not in the website order.
In compliance of the stay order, my lord, we have deposited.
But Miller, see.
On 20th/9/2022, in addition to rupees 25,000 statutory deposit, we have also deposited 4,93,771 before this honorable.
Where is the interim order?
There's a 20th/7/2022 Miller. 20th/7.
20?
22. 20th/7.
Of which year?
2022. I find it in the website, Miller.
In this appeal, it is not there.
Miller's first appeal, Miller's I have read. Second appeal, Miller's
1935
1348. 1348.
1348 is by the insurance company, my lord. In that we have deposited.
Claimant.
Yes. I am for the claimant. Announcement.
It's there, 50% of the
I am
money.
sorry. Website only there is no Miller's.
Let them withdraw. The on 27/2022, that's an MFA number 101348. The coordinate bench of this court has passed an order directing the appellant insurance company to deposit 50% of the amount. Then counsel for the, have you filed the IA?
IA is not filed. IA is
Counsel for the petitioner, respondents seeks permission to withdraw the money. Accordingly, petition is permitted, respondent is permitted to withdraw the money. Yes. TCR is called for?
No.
Registry is directed to call for the TCR.
Please.
Yes, next.
Number 26. Number 26.
If
I'm for respondent
Gracious
number two,
Sulu.
my lords.
you appear for the,
Respondent number two, insurance.
Where is
Narasimhannavar,
no representation on behalf of the petitioner, counsel for the respondent is present. This is marked in the month of March 28.
Number 27. Kindly post party.
I request week time, my lord. I request on 28 it may be taken, my lord.
Why?
I need to file the application for impeding the owner of the vehicle. We sold the vehicle to the third person.
Of February. Yes, next.
Seal number 28.
Hearing for my lord petitioner.
Mantesh.
Hearing for petitioner, my lord.
Vijay Bhatt.
I filed this petition for seeking for my lord appointment of arbitrator, my lord. As per annexure A, my lord, earlier, my lord, honorable court, my lord, appointed arbitrator, my lord. As per annexure A, page number 15, my lord. My lord, I appeared before the arbitrator and my lord, I have filed application for recusal of the arbitrator, my lord, in IA number 1, my lord, under section 12 and 13 of the act, my lord.
Let's see, where is that agreement?
Sorry, my lord.
Where is that agreement between the parties?
My lord, order is, my lord, at page number 72, my lord. Letter is issued by the arbitrator to returning the entire papers to the appellate court, my lord. Lord, in spite of that application, my lord, application came to be dismissed and I have filed writ petition also, my lord. In writ petition, my lord, annexure B is the order passed by this honorable court to reconsider the application, my lord. And my lord, the arbitrator, my lord, reconsidered and once again he dismisses my application and passed the, my lord, order, my lord. And annexure C is the, my lord, order passed by the arbitrator, my lord. That I have challenged before the district court, my lord, at
No, what is the relief you're seeking in this petition?
my lord, a fresh arbitrator I am seeking for, my lord, appointment of a fresh arbitrator because, my lord, district court, my lord, remanded the matter for a cross-examination of, my lord, respondent hearing and adduce the evidence of mine, my lord. After, my lord, remanding the matter, arbitrator, my lord, in view of non-payment of, my lord, amount, he has, my lord, sent back all the papers to the district court, my lord. That is the reason, my lord, I am seeking for a fresh appointment of an arbitrator.
Why you have done so?
My lord, my humble submission before honorable court is,
The other arbitrator will also send everything.
my lord, in view of, my lord, there is a, my lord, non-faith of the, my lord, arbitrator. That is the reason, my lord, I have. And
My lord.
one more submission, my lord, please.
My lord, as per the order of this honorable court, with the consent that arbitrator has been appointed by this honorable court. And arbitral award has been passed by the arbitrator. After passing of the arbitral award, the petitioner herein challenged it before the district court. District court for limited purpose sent the file to the arbitrator, not remanded. Sent the file to the arbitrator to record the cross-examination with a specific condition that since he has not paid the earlier arbitration fees, with a specific condition that he has to pay the arbitration cost. It is a precondition. He failed to pay the arbitral cost. And he, with the arbitrator, he bargained. I pay this
no, my
much.
lord. No, my lord.
For that purpose, arbitrator said,
Say with the arbitrator,
I have bargained, my lord.
you bargain with that.
bargain. As per the schedule, as per the schedule, he fixed the arbitration fees. I have paid my part of the fees. He has not paid his part of the fees. That is recorded by the arbitrator in his order.
No.
Then he returned the file to the district court. Now the petition is pending before the district court. Under section 34, petition is pending before the district court. Now at this stage, after passing of the arbitral award, whether new appointment is permissible under law? No.
My humble submission before honorable court is, my lord, remand order, my lord, by the district court, they have not challenged, my lord. For the, my lord, adducing cross-exam evidence and a cross-examine of respondent
Not
here.
necessary, they are not agreed by that. If you are not paying the arbitrator
My lord,
fees and the arbitrator
There is
returns the
a
file,
provision under act that, my lord, arbitrator has to, my lord, recover fees from me, my lord. I am not objecting for that, my lord. And my lord, after demand for evidence, my lord, I have, my lord, ready to pay the, my lord, the examination of, cross-examination of.
Let's see that order where he has
Please,
returned
my
it.
lord, at page number 60.
60?
Oh, sorry, my lord. 72 may kindly be seen. Order dated 21/11/2025.
Read that order.
Please, my lord. So and so advocate filed wakalat for Vijay Kumar so and so, partner of so and so, respondent claimant, and so Vijay Kumar Kabadi is absent on 14/11/2015. The case is
What was,
adjourned.
case was adjourned, giving 1 week time to the respondent as a final chance for depositing the arbitrator's fees.
Please, my lord. But my lord, I am ready to deposit rupees 15,000 as a, my lord, fees, my lord, for this after remand, my lord, case, my lord, for cross-examining the respondent hearing and adducing evidence, my lord. I have filed memo also with that effect to the arbitrator, my lord. And I am orally informed the arbitrator that, my lord, I have no objection to, my lord, initiate proceeding for recovery of the entire arbitration fees, my lord. So should kindly, my lord,
Therefore, the fees payable by the respondent is rupees 1,30,150.
Please, my lord.
Was kept as a lien as provided by section 39 of the Act. Respondent is not inclined to deposit arbitrator's fees, which he is bound to pay as per section 38(2) of the arbitration so and so. Therefore, the arbitral proceedings remanded with the honorable so and so. You pay the amount, it will go back to him. We'll ask him, we'll send it to, we'll ask the district court to send
My
the
lord, as
file.
per the provision of, my lord, Act, my lord, he can recover the said amount from me, my lord.
Why should, then what is this?
My lord, my humble submission before honorable court is, my lord, it is
It is a precondition.
For
He filed an application before
For
the
recovery
district
of-
court to cross-examine PW1 and to lead his evidence. That application is allowed
You
with a
deposit-
condition.
You deposit the amount, we'll ask the district court to send the file back to the arbitrator to decide it. We will not appoint a fresh arbitrator.
2 days time, my lord, I will consult the parties, my lord.
Does this matter
My lord,
on Monday?
my humble submission before honorable court is today before the trial court it is listed, my lord.
We will not do anything.
Till then, my lord, respondent, my lord, kindly be instructed not to precipitate, my lord. Otherwise, my lord,
No, I have canvassed my argument before the district court.
that is the reason, my lord. If it is posted.
This argument is over.
No, anyhow,
I am not,
we will,
I am
we
not
don't precipitate
precipitating.
anything. Yes, Monday.
not do anything.
Does this matter on Monday? Yes, next.
Number 29, Lingesh V. Kattemane.
Beneficiary appeal millard, connected matter millard, already stay is granted millard in on
Give the
22.
connected number.
22 is kept open millard in the.
Where is that?
Yes, millard.
Division bench.
Yes, millard.
So it is submitted that in a connected matters, division bench has already granted interim order. So as per that same order, notice to the respondents. So and so.
1 and 2
respondent
millard in
number,
the government millard.
1 and 2. Place
Government millard take notice.
SCA takes notice. Yes.
Seal number 30.
Notice to the respondents. 30.
Preeti Shisha.
Insurance company appeal, my lords. Insurance company appeal, my lords. Challenging the on quantum, my lords. My lords, tribunal taken 50,000 monthly income, my lords. It come to 29,385, my lords.
It's a case of death.
Injury claim, my lords.
How much is granted?
My lords, 3,87,882.
The admitted amount.
My lords, 50%, my lord.
50% is the usual order. I'm asking what is the admitted amount. Get instructions afternoon.
Please, please, my lord.
As per your calculation, how much that amount comes to?
Please, my lords, it is fresh matter, my lords.
I know.
Please, please, my lord.
Ask your senior.
Please, please.
Yes.
Preliminary hearing matter. Seal number 31 urgent. Seal number 32. DJ Nayak. DJ Nayak, Kodichittu.
Connected matter is disposed of by this honorable.
Where is that order?
That's that is WP 109977.
Very short.
And externment notice is issued by the sub-divisional magistrate. External.
I have disposed of the other day.
That is 109977.
Same order.
Same order. Liberty may be given to file explanation before the.
The other day I have disposed of the matter. Who has taken this? Find out. Same, in like, same order. Facts may differ.
33 same, my lords.
Yes,
33,
next.
34 and 38 months.
32, 33,
34,
same.
38. Last.
38 also. Yes.
Please.
Serial number 35. Srinivas Naik. Srinivas Naik.
Notice.
Issue notice. Serial number 36. I.Y. Patil.
Similar matters are
I.Y.
listed on
Patil.
20th. Similar, it is case of parole, my lords. Similar matter listed on 20th, my lords.
20th.
20th.
List along with the other matter on 20th. Yes, 37.
Serial number 37.
Please.
Anand Bhagavat. Chetan Munwali.
Seeking mandamus, my lord.
My apologies, my lords. In this case, before notice only, my lords, I filed wakalat for respond number 2 and 3.
Who is respondent number 2 and 3?
City Corporation Belgavi, my lords. And it's another official. My wakalat may kindly be accepted. One more sub. Yes.
Yes.
My lord. Seeking mandamus to direct my respondents, my lord, to consider my representation. That is only.
What is the representation?
My lord, next year. Next year, H series, my lord, page number 46. Page number 46. The City Corporation Belgaum is sanctioned former 1 and 2 pertaining to PID number so and so. The said property was not registered sub-register office and it was purchased by bail bond papers, which is not legal purchase.
How are you concerned with this property?
Lord, that property is not gifted by my wife, registered gift deed, Lord. And earlier that I purchased the property some other person, Lord. After that, my lord, my wife, Lord, gifted to me.
Let's see the facts. What is the...
Please, Lord. Annexure A is the Lord gift deed. Annexure D, Lord, it is a registered gift deed, Lord. Annexure D. After that, I obtained permission from the authority to construct a building.
What is this PID?
It's property identification number.
No, their names are not mutated.
Initially, their names were mutated. Subsequently, other private parties' name has been mutated. Notes, today morning, I received parawise remarks and some documents. I may seek on Monday, my lords. I'll.
Let him, so that unnecessarily thought.
It can be discussed.
Does this matter on Monday?
Please, my lords. Bless.
The request of land council appearing for the respondent municipality.
Notes, wakalat may kindly be accepted.
Yes, wakalat is taken on.
Please.
Serial number 38 disposed of. Serial number 39. 39. Tarikar Praveen. Praveen Tarikar.
Is that? No representation on behalf of the petitioner. Notice to the respondent, list this matter in the month of March. Yes, 40.
Serial number 40. H. Bagi.
I'm for appearing for the petitioner in this matter, Your Lordship.
Yes.
The matter pertains to e-auction sale notice, Your Lordship. As per the annexure J.
What is wrong with the notice?
Already the only one EMI is pending, Your Lordship. As per their version, I have paid till today 24 lakhs as per the direction of the honorable courts. First is I have challenged the e-auction sale notice.
Take out hand
Please, Your
summons.
Lordship.
Petition is permitted to take out hand summons on the respondent and shall file a memo to that effect. If the memo is filed, whenever the memo is filed, is the matter. Yes, 41.
Serial number 41.
Your Lordship, serial number, Your Lordship, on submission, Your Lordship.
Yes.
Your Lordship, the e-auction sale
Yes.
notice has been taken on 15 of this month, Your Lordship.
But I'll not grant any interim order in this. List this matter on 19th. By that time, you have to file the memo or else we'll not consider it. Yes.
Obliged, Your.
My lord. Tender matter, my lord. Tender matter, my lord. Challenging annexure A, my lord.
What is this TN means?
Tender matter.
Tender
matter.
Hmm.
My lord. Annexure A, my lord. The respondent number 3 has issued the tender notification, my lord.
Hmm.
As my lord, in annexure B, my lord, annexure B is a circular, my lord, issued by the commissioner RDPR department, my lord. Rural Development and Panchayat Raj Department, my lord. Along with the model tender booklet, my lord, at annexure C, my lord. The conditions has been imposed in the model tender booklet at annexure C, my lord. But respondent complied and not followed the conditions and
24/8/2025 is the tender notification.
Yes, my lord.
Please come to the tender notification.
Yes, my lord.
Page number?
Page number 13, my lord.
Page number 13.
Yes, my lord.
Yes. Which clause in the tender is?
My lord, a relevant page at page number 19, my lord. Last line, my lord. Roman 3, my lord. The bidder agency, that is company, firm, proprietary concern, should have minimum 3 years of experience in supply manpower in the relevant fields. That is providing personal in engineering or diploma in civil or computer engineering fields. Next page. Graduates or computer operators as manpower agency or manpower suppliers. But my lord, the model tender booklet, my lord, issued model tender booklet at annexure C, my lord.
Page number?
At page number 62, my lord.
Yes.
Roman 3, my lord. The bidder agency, that is company, firm, proprietary concern, should have minimum 5 years of experience, my lord.
What are these guidelines? Please come to the first page. Government Karnataka, Office of the Chief Executive Officer. Invitation for bids. What is this?
Lord, for Manrega, my lord, Mahatma Gandhi National Rural Employment Guarantee Act.
So why the same condition should be there in all tender notifications? Who says so?
My lord, it is issued by the commissioner, my lord, RDPR department, my lord, and it is applicable to all the districts, my lord.
That's why I'm asking. Where did it say so?
My lord, annexure B, my lord, circular, my lord.
Government of Karnataka Jilla Parishad tender notification for the selection of.
My lord, circular at page number annexure B, my lord.
Page number.
Page number 52, my lord.
52.
That is in Kannada.
What it says?
ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಹೊರಗುತ್ತಿಗೆ ಸಿಬ್ಬಂದಿಗಳ ಸೇವೆ ಪಡೆಯಲು my lord, the tender booklet is attached along with this circular, my lord, saying that these conditions must be fulfilled, my lord, while issuing the tender notification of the RDPR department, my lord, and issued to all the district, my lord.
My lord, kindly see, according to his own assertion,
And it
respondent
is
number
not the only
6,
ground.
respondent number 6 has been qualified, he has been selected, my lords. There is a appeal provision under section 16 of the act. If any orders have been passed in selecting them as respondent 6 as a successful bidder, he has to challenge under 16 of the, my lords, the act, KTP Tech. May take, my lordship, in consideration to section 16 of the act.
No, auction was when? Notification was on 25/8/2025.
Yes,
And my lord,
When was the auction held?
my lord, work order is
My lord,
not yet issued, my
my
lord.
lords, his
So when was
condition
the
is,
auction held?
25/8/2025, my lord.
Date of, this is not the date of auction.
it is not a question
Notification.
of only eligibility criteria, only is, my lords. Eligibility criteria, he is challenging before this honorable court.
Eligibility criteria, my lord.
Eligibility criteria, he is not qualified, according to him, respondent number 6.
That's what I'm asking.
Please.
When was the auction is scheduled? As per the auction notification.
Yes. That's action notification is, my lords, 25/8/2025.
Yes. When is the auction?
My lord, there is no,
When is tender is, when they have opened the tender?
my lord, at page number 23, my lord.
20?
23, my lord. Start date of uploading of tender notification 25/8/2025, my lord.
Pre-bidding meeting
Pre-bid
38.
meeting on
Yes, madam.
38, my lords.
Last date for receiving the bids 39.
Yes, my lords.
Submission of the proposal, opening of the bid 3010.
Yes,
Financial bid.
yes.
So this is, the last date was on 6/10/2025.
My lords, he is not on the, my lords, the time limit.
My lord, I have challenged also.
I understand what
Please.
he is.
Yes,
What I'm saying is when this writ petition is filed,
yes.
what is the date of this writ petition? This is on
This is on
6/1/2025.
Yes.
So when the tender notification is issued on 25/8/2025, you didn't realize all this.
Yes, my lord.
Now, when you are not selected,
No, my lord, work order is not issued, my lord.
forget about the work order.
Yes, my lord.
When you have seen the tender notification, that time you were not aggrieved by with all these conditions.
He is a participant.
My lord, I have participated, my lord.
That's what, you are not aggrieved by that time. When the financial bid is open on 6/10/2025,
Yes,
when you were not shortlisted,
Yes,
then
ma'am.
you understood that it has to be questioned and that is contrary to the, the circular issued by the
My lord,
commissioner.
my lord, I have given a representation, my lord.
When
At
is the
annexure
date?
G, my lord, 105, page number 105, my lord.
105.
My lord. My lord, one bidder, my lord, BKR Services Private Limited, my lord.
What is the date of that? Your representation date?
18/10/2025.
18/10/2025 also, when you were already you were not selected.
I have selected, my lord. My lord, I have produced
That is,
copy of
that-
bidders, my lord, 103, my lord, page number 103, my lord.
that representation not to the authorities, appellate authority. He has,
My
my
lord,
lords, given issue.
one
to
bidder,
the
my lord, that is BKR Services Private
Now, on
Limited.
6/10/2025,
Yes, my lord.
who are the shortlisted candidates on that day?
My lord, at page number 103, my lord.
Are you there?
Yes, my lord.
Huh?
I'm there, my lord. But my lord, at BKR Services
Page number?
103, my lord.
Who are the shortlisted in that?
My lord, five bidders, my lord. Varada Prasad,
Where are you?
my lord, I am at page, serial number 4, my lord. My lord, yes, at page number 104, my lord, one of the bidder, my lord, his company registered on 16th May 2023, my lord. He has not completed 3 years, my lord, as per their tender conditions, my lord.
That's a different aspect.
Yes, ma'am.
If a person who is not qualified.
My lord, he is
if
not
they-
technically, he is not eligible, my lord.
That is
Then
not
also,
your point.
he has
You are
been.
only on the point about the criteria, the qualification criteria that is fixed by this tender is contrary to the circular issued, which you have not questioned when the circular is issued. When the
My
notice
lord, it is
issued.
not the only ground, my lord. I have produced annexure J, my lord. The final order issued by this court, my lord, wherein, my lord, the timeline for each activity has been discussed, my lord, at page number 113, my lord. Timeline from the last date of submission of tender, my lord. And the last date for submission of tender is, my lord, 30/9/2025, my lord. From that 90 days is, my lord, 30/12/2025, my lord.
I think you are mixing too many issues in this. The prayer that you sought is something else. Whatever
No, my
the
lord.
available
My lord,
grounds are,
I am
you are
seeking
taking
for
now.
quashing of tender notification and issuing of
Only
fresh
on
tender
that
notification,
ground.
my lord.
Now, what I am saying is a person who has participated in the tender process, at this point of time, you cannot question it.
And he has participated, he has unsuccessful bidder, someone has
My lord.
participated, he is also not made as a
Financial bid,
part.
I am eligible, my lord. Work order has been not issued to the any of the bidders, my lord. Still it is pending, my lord. And my lord, there is a circular, my lord, at page number 113, my lord. Issued by this honorable court, my lord. Timeline from the last date of submission of tender, my lord. And last date for submission of the tender, my lord, 30/9/2025.
Let us first of all make the facts of your case. What are the grounds for assailing that? First, that we have to consider.
Yes, my lord.
Let's forget about what this court said, what somebody else said. So according to you, the only ground which you have raised is, please come to the grounds.
Page number 6, my lord.
Yes. Let's see.
Yes, ma'am. Madam, letter of intent ought to have been issued on the 70th day, my lord. As per annexure J, my lord. The judgment of this honorable court, my lord. Has been discussed in page number 113, my lord.
So that is one of the conditions. 5 years is one of the conditions.
Yes, ma'am. The tender notification should be concluded
Is it
on or
granted
before.
in favor of BKR Services Private Limited?
According to his assertion, it is already, my lords, given to
But my lord, he is technically.
BKR Service Private Limited, para, my lords, in page number 4, para 6 of the, my lords, the adjournments.
Was he a party to this?
He is not a party.
Make him a
My
party.
lord, work order is not issued in favor of BKR services, my lord. He made eligible, my lord, even though they,
Have any instructions in this?
No, my lords, first time it is coming.
my lord, even though,
Instructions, the respondent shall get instructions whether the contract is awarded in favor of
BKR services.
BKR services or any other services. This is matter next week. Yes.
Next, my lord, till date work order.
Yes.
Number 42. Ramchandra Mali.
My lord, respond number 3, maybe, respond number 3, my lord, Jilla Panchayat Haveri. Kannur is appearing for respond number 3.
In which case earlier one?
41.
41 so and so.
Kannur.
Directed to take notice on behalf of the
But-
respondent number
3, my lord.
3. 42.
I take notice for R1 and R2 in that case. 41, I take notice for the, my lords, other respondents.
R1. Yes. 42.
42, my lords, I am challenging the compromise decree in the FTP, my lords. Compromise decree has drawn against the dead person, my lords.
You are challenging the compromise decree passed by who?
Passed in the FTP proceedings, my lords, senior civil judge, my lords.
Then why should you file a writ petition against that?
My lords, without making me
Still,
Lok Adalat decree, my lords. It's a Lok Adalat decree.
Lok Adalat.
Lok Adalat decree.
Where is that?
My lords, annexure E1, my lords, page 91. Relevant, my lords, at 95. My lords, in the cost letter, my lords, defend number 10, Vittal Krishna Paul is the one, my lords, this is.
Where are you?
Serial number 10, my lords.
Serial number Shri Vittal.
Vittal Paul is the one deceased, my lords. Death certificate is produced along with the memo,
His LRs were not brought on record.
not brought on the record. The petitioners herein are the LRs, my lords.
How many in number?
My lords, 2, my lords. Annexure A2, A1 is the death certificate, my lords. A2 is the
Petition is filed, agreed with the compromise decree that's passed in the, but before the Lok Adalat in FDP number 34 of 2023. It is the contention of the legal counsel for the petitioner that he is arrayed as his father is arrayed as, the father of the petitioners is arrayed as respondent number 10. He died on
29/9/2019, my lord.
2019 and the compromise decree was passed on
12/17/25.
12/7/25.
Please, my lords.
12/7/2025. It is submitted that there is a compromise decree against a dead person, and they have filed before this court the death certificate that's issued. Considering the same, they shall be. Where is the where is the prayer?
Lords, prayer at page 19, my lords.
There shall be stay of operation of the implementation of the and execution of all further proceeding pursuant to the compromise decree dated 12/7/2025 passed by the senior civil judge JMFC Nippamani made in FDP number 34 of 2023.
My
Notice
lords,
to the respondents.
I am seeking dispensation of notice from respondent 15 to 32, my lords.
Why?
They are the co-defendants along with me, my lords. They are sealing along with me. The share has been only,
Oh, a compromise decree that is between everyone.
no, my lords. The compromise between is not everyone, my lords. Only respondent 1 to 12. They appeared, they themselves have drawn the compromise decree, my lords.
Unnecessarily, we shall not create any confusion. Let notice go to everyone.
Please, my lords.
Yes. Yes, next.
Seal number 43.
This, my lords, application was filed before the executing court. My lords, we are the decree holders, my lords. Annexure A is the decree, suit for permanent injunction which was decreed. And annexure A, my lords, page number 14 may kindly be seen. Suit is suit of the plaintiff's decreed. Hereby the defendants want to fire restraint permanently from interfering with the plaintiff's peaceful possession and enjoyment of suit property shown at letters A, B, C, D in the plain sketch. My lords, I have produced the plain sketch also, which is part of the decree at page number 18. Now, my lords, there was obstruction by the defendants. in respect of ABCD portion, my lords. As such, application was given, which was not considered. And my lords, they have denied the encroachment. That's the reason, my lords, EP was filed. Pending EP, my lords, now, since there was denial of the encroachment, now, my lords, application was filed for appointment of court commissioner to demarcate, my lords. That has been dismissed by the executive. Please.
Where is the order?
Order, my lords, is at Annexure J. Page number 47, my lords, para 15 starts. I read the relevant portion. Page 47.
Let's read from the reasoning.
Please, from reasons, my lords. The learned advocate for DHR filed I number 4, praying with this honorable court to appoint ADLR Gadag to make the measurement of the suit property, non-agricultural land bearing RS number so and so, and building existing thereon, and also every part of RS number so and so, present Budishwar Hosaldi village of surrounding adjacent to it, in the interest of justice. In the affidavit accompanying this application, the DHR number 4 states that the DHRs have obtained a decree for permanent injunction by filing OS number so and so and on so and so against the JDR number 1 to 5. JDR number 5 is the Panchayat authorities have made attempt to violate the order passed by the court on so and so. As such, present petition is filed. In this petition, the evidence of DHR and JDR is recorded. DW1 in his cross-examination has stated that he has filed for applied for measurement of his of the property in this suit, including road existing towards east of RS number so and so. DHR has also applied for measurement of their property, including the suit shell property, by filing application to the ADLR dated 2022. The JDR number 5 is intending to widen the road by making encroachment of the property of DHR. JDR number 5 represented by JDR 6 has issued notice in writing on 25/1/2022, which is contrary to the decree operating against the Panchayat. The JDR are claiming a false claim over eastern portion of land bearing RS number so and so. As such, it is necessary to measure the property of DHR to fix the boundaries to the entire RS number and measurement of all the parts of RS number 181 of village. The report of the commissioner is necessary to effect adjudication of the case. Appointment of court commissioner does not cause any harm to the other side. On the other hand, the learned ADCP for JDR number 4 has filed objections denying the contents of I number 4. The present application is not maintainable either in law or on facts, hence pray to dismiss the application with cause. The learned advocates for JDR number 5 and 6 filed his objections and contended that there is no necessary for appointing ADLR as court commissioner for local inspection to make measurement of every part of RS number 181. The DHR mainly alleges that JDR number 5 and 6 have tried to remove the boundary fencing existing along with the eastern boundaries, and they are putting the new drain by the side of the road by encroaching the said suit property. Under such circumstances, the appointment of local commissioner is irrelevant and unwanted. The DHR are having intention to get measure their property through court. A road is existing at the eastern side of the suit. Now I am seeking for stay of my own execution proceedings for the reason now executing court, my lords, is dismissing the execution petition. My lords, again it will be multiplicity of proceedings for the same reason, my lords. My own execution proceedings I am seeking for stay. Otherwise, my lords, it is now
Notice to the respondent.
till next date, my lords.
It is permitted to take out hand summons on the counsel appearing for the respondent before the executing court and shall file a memo to that effect. Once a memo is filed, it's this matter.
Date may be fixed, my lords.
Whenever you file, it will come. If it is not, you can mention.
Please, much.
Number 44.
For petitioner, my lord, here petitioner has challenged the order of the District Consumer Dispute Redressal Commission Belgavi, my lord.
Why should be challenged before this court?
Please, my lord, because my lord, the first note is that, my lord, between the petitioner and the complainant respondent, there is no relationship of consumer and service provider.
Whatever it is, you have to go before the state commission.
Please, my lord, but I annexed one judgment at annexure H, my lord, at 77. The High Court of Bombay has entertained the petition. Even, my lord, this honorable court has entertained the and stayed
the way we do it. Every matter, High Court will not interfere.
Please, my lord, but here, my lord,
there is the hierarchy of.
I'm an ex-employee of the society. Even
whatever it is, go before the state commission and tell that it is wrong. Why should the High Court interfere?
My lord, even this honorable court has.
Might be intermodals are not binding on the court.
But the.
Will not. Please go to the state commission.
The redressal has passed. The commission has passed without jurisdiction, my lord.
No, can't the appellate court set aside that? Appellate tribunal can't set aside it.
Please, my lord,
It can set aside. So
but
please
again, my
don't-
lord, it,
Don't come to the High Court for everything.
my
Everything
lord,
under the
one
sun.
submission, my lord. Otherwise, again, I have to approach the.
You should have gone there. Why
National-
did you come here? District Commission, against an order of a district commission, how can you come to the High Court?
No, my lord, warrant has been issued, my lord. Even notice has not issued to me, my lord. The principle of natural justice also, I am before this on the.
Like this, if you know the advocate practicing in the High Court, jurisdiction for everything in the High Court.
Pardon, my lord. Even notice was not issued to me.
Maybe all these, please tell the court whether the state commission can look into that or not. It can look into whatever the procedure that is available before this court, same procedure there, it can stay. Why should we interfere with that?
But my lord, as per the Supreme Court judgment, my lord, when there is a lack of jurisdiction and the principle of natural justice has been violated, this honorable court has the.
No, that the state commission can also do. If it is done, state commission can also do. If you say that it is not an effective alternative remedy, I can understand. State commission will not ask you to deposit the money. State commission will not take years for deciding it, because an IA you can move before the court, isn't it? I'll give you a week's time to approach the state commission, till such time not to do. But don't, I'll not entertain this petition. The
My lord,
present
but
petition-
this honorable court was
Give that.
already
I
entered.
I will record it and pass orders. Take that.
Otherwise, pass over the matter. Senior.
If your senior comes, then not even 1 week time I'll grant. For you, I'll grant 1 week time not to take any coercive steps. If your senior comes, I will dismiss it as not maintainable. So think and then make a request. Yes.
Please.
Yes, next.
Serial number 45.
Serial number 45, 46, then my lords 48, 50, 51 and 52.
45, 6.
45, 46, 48, 50, 51 and 52.
50.
51 and 52.
Hmm.
That's, they all are same, my lords.
Hmm.
The very same
Tender notification.
Yes.
My lords may kindly see, my lords, 45, my lords could kindly take it up. My lords,
100, 122. Yes.
yes, my lords, 100, 122 of 2025, 26. My lords, this is a case, my lords, where the respondents, my lords, have invited for tenders. My lords, tenders, my lords, pertains to, my lords, providing the mobile medical units or mobile clinic units. These are all, my lords, small ambulance type, my lords, vehicles, which will be provided by the state government. And my lords, the petitioner, my lords, is a registered society under the Societies Registration Act. And these societies, my lords, will be permitted, my lords, to take these mobile medical units and, my lords, station in a place where, my lords, the massive construction would take place. And it is for these mobile medical units, my lords, are meant for the purpose of the construction workers, my lords, who would be doing the construction work. My lords, how it works, my lords, if I could kindly explain. My lords, if there are certain construction works, my lords, going on in a particular locality, they will identify, my lords, as to how many construction work is going on, irrespective of whether it is a government construction, private construction. Identifying so, my lords, they will assign one mobile medical unit with one doctor there, and, my lords, one helper or attender, or, my lords,
Which one? Ministry of
health. And, my lords, these mobile medical units, which are in the nature of ambulance,
state government.
state government, will be, my lords, given by the state government itself. And, my lords, all the other facilities, my lords, also will be given by the state government. The tender, my lords, is only for the purpose of maintaining these mobile medical units with one doctor and, my lords, one attender.
Only maintenance of that mobile.
Maintenance, and, my lords, providing the medical services to these registration, the health checkup, my lords, for these workers. And, my lords, it's not a case, my lords,
Be providing the doctors also.
for, my lords, cough, cold, fever, and such other, my lords, minor ailments which these construction workers would be suffering, and their dependents also, my lords, would be given this medical care, my lords. My lords, in the year 2022, my lords, they called for a tender. Kindly see, my lords, the tender conditions, my lords, which existed in the year 2022. My lords would find that page 45.
Yes.
The first criteria, that it should be the limited liable partnership firms or we don't, have any objections. Then, turnover, it speaks about 8.29 crores. Then, they say that, should have successfully operated and managed 10 medical care units for the state's government. Bidder should have registered with Niti Aayog, should have ISO registration, and should be authorized signatory, self-declaratory by the authorized signatory of the bidder's sponsor. Bidder shall furnish the details of the boards with PAN and Aadhaar cards. These were the 9 conditions, which stated. Since, it's a small registration, the societies, which are registered, small entrepreneurs, used to participate. They used to provide, participate. There used to be bid, and they have successfully completed. And, the satisfactory certificates have also been issued by the respondent authorities, for these tenders. Now, after the tender period gets over, they call, for the fresh tenders. Now, fresh tenders, would find the eligibility criteria conditions at page number 102. 102. First, it should be a registered society. I don't have any objection. Second is, they are expecting the bidder should have minimum average financial turnover of at least 29.40 crores in the preceding, at least. Average financial turnover of at least 29.40 crores in the preceding 3 financial years. They specify the financial years also. This is one condition, which is very much arbitrary. Then, the second condition, that condition number 3, the bidder should have successfully provided medical services through medical camps, preventive health checkups in mass levels with at least 15,000 patients. That is second condition, which is also arbitrary. Then, the third condition, this
is arbitrary. Now, for the first time, they have done it in 2022.
Please.
No, after that
3 years,
after
the 3 years
is over,
period.
They must have realized what should be the eligibility criteria, and they have done it. Just because you do not suit, it would not become arbitrary.
My humble submission is that, there should be a nexus, between the act and the object sought to be achieved. That is well-established principle, Now, these, if at all, my lords could kindly take, these conditions, are so well designed.
But the bidder should have successfully provided medical services through medical camps. 15,000 patients.
15,000 patients, 15,000 patients.
They wanted a qualified team for
qualified, 15,000 patients, it is designed only to suit a particular person only. It is tailor made in such a way that it suits a particular person, and I'm ousted, even before applying. That is their object. And if my lords could kindly see the fourth condition, the bidder should be registered with KPME, and the same shall be displayed on KPME website.
What is KPME?
Karnataka Private Medical Establishment. I will just, establish that. If my lords could kindly see this Karnataka Private Medical Establishment Act, it says, my lords, for registration, who is eligible for registration, my lords? It says every person, Karnataka, please. Application for registration, every person desiring to establish, run, maintain, or continue to run and maintain a private medical establishment shall make an application to the concerned registration authority in such form, in such manner, and along with such fees as may be prescribed, and different amount of fees may be prescribed for different class and classes of the private medical establishment. This Private Medical Establishment Act, my lords, has come into force in order to, my lords, regulate the big hospitals. Not, my lords, these small entrepreneurs.
So that's what I asked.
Yes.
You are doing you are providing them medical facilities.
Yes.
You're providing them with
small time, my lords. It's a small scale level. Not that, my lords, I'm having a big establishment.
You are establishing.
No, kindly see, my lords. Kindly see, my lords. If prerequisite for registration of private medical establishments. If I want to apply for this, what is the requirement? Prerequisite for registration of private medical establishment. The registration authority shall, before granting the registration, consider whether the following prerequisites for registration of a private medical establishment are satisfied, namely, that the premises housing the private medical establishment is located in hygienic surroundings and otherwise suitable for the purpose for which it is established or sought to be established. Mainly, my lords, if my lords could kindly see, they are only referring to the premises. They are referring, my lords, to the premises housing the private medical establishment is located. That means there must be a proper immovable property. Then, my lords, the private medical establishment is adequately staffed with qualified doctors, qualified and trained paramedical personnel. Private medical establishment has the necessary buildings with adequate space for performing its various functions, equipments, and other infrastructure that the private medical establishment confronts to the standards referred to in section 9. Such other factors as may be prescribed. So, my lords, these are all the Private Medical Establishment Act is meant, my lords, to regulate the big hospitals. Now, my lords, in the present case on hand, the mobile medical units, which are in the nature of ambulances, will be given by the state government with equipment. I'm only there, my lords, to provide a doctor, my lords, and a staff nurse for the purpose of, my lords, looking into how this, for the purpose of small medical follow-up checkups, small medical checkups, my lords, for the,
How much in number?
please, my lords.
How much in number?
My lords, it all depends upon different regions, my lords. Supposing, my lords, if Dharwad region, my lords, has got huge number of construction, it all depends upon the number of units that is required. Please.
How many units?
How many?
How many how many equipments are given to that take this?
My lord, depend upon the region wise, my
For
lords.
example, Dharwad,
Yes, my lords.
how many?
Maybe 7 mobile units, my lords, would suffice. Now, my lords, for which they say 29.04.
Participating, it is for a
They
particular
want me to
region?
oust, my lords. In fact, in the year 2022, I have satisfactorily completed the small entrepreneurs. They just want the small entrepreneurs to be eliminated altogether. None of the small entrepreneur, my lords, would be in a position to apply if such, my lords, conditions are imposed. This is very much, my lords, arbitrary in nature.
No, that's what it is. That's the difficulty in fixing the tender criteria. That's for the person who is issuing the tender, what is their requirement? Just because on the last occasion, the conditions were otherwise, you can't compel them to have the same conditions this time also.
Lords, at least there should be some reasonable nexus, my lords, between the act and the object sought to be achieved. Now, my
What
lords,
is the law on that?
Karnataka private medical establishment has nothing to do with the present case, present act.
Even if that
Then
particular
if
clause-
that condition number 5 also may kindly be seen, my lords, it says the bidder should have engaged at least 35 medical and paramedical staff on their payroll for the past 1 year. Then, my lords, just opposite, next column.
It is
No,
absolutely.
next column, next
no,
column.
That is absolutely
Just-
reasonable,
No, my lords.
reasonable condition.
No, next column, next column. HR of the organization certified salary statement of preceding 3 months. That is, my lords, July 2025, August 2025, and September 2025 have to be specific, have to be given. Only for the year 2025, they mention months.
No, where are you reading it?
My lords, just opposite to that, my lords,
Picture of the
5.
organization certified
Then-
salary statement. Because that means you should have in-house doctors and paramedical workers.
No, particularly, my lords, for these 3 months, they demand, my lords, salary statement of preceding 3 months of pertaining to July, August, and September 2025. Please.
Tender called for?
Tender called for,
When was the tender
my
notification?
lords, tender notification, my lords, has been issued on,
Page 79. In page number 79, my lords,
it
the
has been
issued on, my lords.
19/12/2025, my lords. 19/12/2025, tender notification is issued.
That's what, preceding 3 months.
Please.
Preceding 3 months.
Yes, my lords.
Hmm.
19/12/2025.
Yes.
So therefore, my lords may kindly see, whenever, my lords, such arbitrary things are there, on judgment, my lords, I would like to, there is no, my lords, opportunity at all for the others to participate. My lords could kindly see, the very same question, my lords, is the 2025 latest judgment of the Honorable Supreme Court, paragraph 15, my lords, page 4.
Yes.
Yes, paragraph 15 may I read, my lords.
Hmm.
Lords, before proceeding further, it is opposite to beliefly advert to the counters of judicial review with it.
How they can give this survey, how can you participate? The society which has no experience in this providing medical personnel, medical
No, we have
professionals.
medical. If at all, my lords, the conditions, my lords, which existed in the year 2022, or some reasonable conditions, my lords, if they are able to insert, then, my lords, will be, it is meant only for ousting, my lords, all of us. Serial number 47 to 52, my lords, there are about 7 petitions which are listed before your lordships today. This is meant exclusively for ousting all these registered societies, my lords, out of the, my lords, fray altogether.
Petitioners have the experience of executing such works.
Such works,
That
my
is our
lords.
case.
That is our
And we have
case.
produced the certificate to that effect also.
Lords, Karnataka Private Medical Establishment Act, my lords,
May, this is a policy decision of the state. And they have no locus to challenge these matters because they are not qualified, they are not qualified. It is a policy decision of the state. And the government, in the wisdom, my lords, has thought that it should be enhanced to the such conditions, maybe, my lords. Also kindly see in the first petition, their grounds is, my lords, it's in page number 7 of the petition. They challenge only with respect of, my lords, this, my lords, the data, and that is, my lords, with respect of their qualification. And merely because they participated on the previous years, that will not give any vested right to them to, my lords, participate in this. And today is the last date for, my lords, the closing of bidding, my lords. In page number 79, 12/1 is the last date of submission of proposal. At the fag end, they have come and they say that, my lords, they have also qualified.
No, you do not, any of these qualifications,
Yes.
right from
Page 44.
2, 3,
4,
5.
5.
None
Yes.
none of you have these, you are qualified.
We will not, my lords.
They
We
will not qualify.
We will not qualify.
My lords, it is the, my lords, the government to think what conditions should be imposed and what is the quality of service it should provide to the, my lords, the construction workers. And they cannot dictate the government to, these are the conditions, so that suit their eligibility to get into the, my lords, the bidding process.
Plus one more circumstance, page 44, which my learned friend was referring to. Clause 2 may kindly be seen.
44.
44.
Yes.
Please, the bidder should have annual turnover of minimum 8.29 crores in any 1 year of preceding 3 financial years. Now the condition is that for all the 3 years, I should have
29.40 crores.
That is one aspect. Second aspect may kindly be seen. Clause 3. The bidder should have successfully operated and managed at least 10 MCUs
Medical.
for any state government, central government department, boards, government organizations in at least 3 years. The present condition may kindly be seen.
Page 10.
103. Clause 4, 3 and 4. This clause was never in existence in 2022.
Why should it be? Why should it be? It's for the person who was issuing the tender to have the eligibility criteria basing on how it worked out earlier.
And that, no, my respectful submission is, that is what my learned friend has made a submission, that should have in excess to the purpose. If at all they are intending to have 35 lots of medical units, and they expect that to have a 29.40 crores annual income for all the 3 years. Because all minor and not small and medium size entrepreneurs will be totally excluded. Totally
Only to exclude, my lords, only to help the big one, my lords, to participate, and my lords have this thing, this has been
and it is
designed.
not that we have no experience. We have experience. We have produced this.
What is your, how do you, this 3 you fulfilled last year? Not 3, what is that, 2, 8.29 crores?
Yes, yes.
What is your annual turnover?
My lords, these annual turnover, my lords, we have to secure
No,
instructions.
how much?
We will fit in, my lords, we will fit in this.
Then-
Earlier tender conditions.
Then coming to 3 is
Lords,
absolutely, there is nothing wrong
My lords,
with 3.
fourth condition, my lords, KPMA registration, my lords, is absolutely. 3, my lords, work order value of minimum 1.75 crores should be completed. That is also, my lords, work order value of minimum 1.75 crores should be completed. They say 15,000 patients, 1.75 crores work value should be completed. KPMA registration is required. Then, my lords, then preceding 3 months, they specified specific months. If my lords could kindly see,
To give a qualitative medical facilities. to
this
the
is not,
people
my lords, even in fact, my lords, even in the, whenever the tender conditions, my lords, as it existed in the year 2022, we have provided the quality medical facility.
22 was the first time.
No, it has been, my
No,
lords,
they
even previous also years.
They experimented it and they felt that now with all these conditions.
My lords,
they'll be
with
able to give a-
these conditions, my lords, KPMA registration is absolutely not required.
Even if you take out the KPMA registration, 3 you will not fulfill.
Yeah, at least, my lords, then 4 may kindly be
5
considered.
you will not fulfill.
At least, my lords, one condition will oust me, my lords, from participating in the tender. If I am not able to satisfy one mandatory condition,
One condition if you say, what about the 4 conditions?
Lords,
Which you are
4
not in a position to
Lord,
participate.
let them justify, my lords, let them justify as to how, my lords, this is reasonable nexus. They have, my lords, with this kind of, my lords, in order to, my lords, exclude the small entrepreneurs.
So 5th condition is absolutely correct. The bidder should have engaged at least 35 medical and
Yes.
paramedical staff. The bidder should, even forgetting, notwithstanding.
My lords,
clause
35 medical and paramedical staff, my lords, may kindly see, if they give me, my lords, 7 ambulance units to maintain or 5 ambulance units to maintain, I will have, my lords, 5 persons on rolls.
Where it is, that's
Then,
where
my
it
lords,
is.
if at all they want, my lords, if they increase it from 5 to, my lords, 35 was not required.
No, you are having 7, you are given 7 maintenance of 7 ambulance
Yes.
services. No, somebody like every person has his own problems. If somebody is not, like is on leave or something, how will you manage? So what they want is if they have a 30, a big institution will be able to manage better because they have the.
No, on their
more,
payroll, my lords,
resources.
staff on their payroll for the past 1 year.
1 year.
Not that, my lords, some alternate arrangement is given something, but for the past 1 year, my
For
lords.
this court to interfere in this.
No, my lords, but if my lords could kindly see, this is tailored, my lords, only to help those big entrepreneurs.
No, if that is, if it is, if it is, if it
Not
is
small
helpful,
entrepreneurs,
if
my
it
lords,
is
all of them
helpful
are
for the
before your
common
lordship.
man, then why should we come in the way? This is not for encouraging your business. It is
No,
for
no,
the
no, not at
welfare
all,
of-
my lords, not at, my
welfare
lords,
of the
all,
common
all
man.
7 entrepreneurs, my lords, are your before your lordships. All the small entrepreneurs will be wiped out, my lords. Only 1 person, my lords, or 2 persons, my lords, who are having, my lords, who are multi-millionaires, my lords, will alone be, my lords, and if they have such, my lords, big units, it will be very difficult for them to
What were their
control.
objections? Because I'm not convinced.
If I may be permitted, the competition in these tenders will be eliminated, facilitating only those high-class elite level bidders who can afford to satisfy these conditions. When the competition itself is eliminated, the very purpose of tender stands
But
vitiated.
here is not the condition of competition. Here is the condition where the people should get a better facility. Who is in a position to provide the better facilities?
Indeed, my lords, we have already done that without raising any ground for, rejection of our services. We have been approved for this. We have done this already previously, my lords.
Satisfactory certificates are also issued by the very same authorities, my lords, for the way in which we have, my lords, given the services on an earlier occasion when we participated.
No, this turnover suddenly from 8 crores, why it has gone to
Lords,
29 crores.
My lords, it is the, my lords, the wisdom of the government, which has, my lords, they decide. Alala, it is not.
Reasonable.
Hello, one minute. It is not an arbitrary, my lords. My lords, in order to give the, my lords, the better facility.
Why did you give them the satisfactory certificates when they were not doing?
My lords,
it correctly?
previously they were working, my lords, they have done, we have given certificate.
Then
Now,
if those criteria is working out from 8 crores to 23 crores, why should it go?
yes, now the government has decided to give, my lords, better facility to the mother construction workers. My lords, by way of providing, my lords, the registration, the KPME. Lords, only to see that, my lords, the fake doctor should not treat the, my lords,
Oh, that's correct. But one thing I'm not able to understand is from 8 crores to 23 crores, there should be some criteria for that, isn't it? Remaining, I can understand
Yes.
having those many doctors on their payrolls and all is fine.
Yes.
So this turnover of 8 to 23, 29, that too very like a Bata price, 29.40. Why?
That's my lords, now the time they have approached this honorable court.
I will not say this.
Yes,
I will
this
not
is the-
say this. Please get instruction.
Yes.
This is matter on Monday. By the time the council for the AGA shall get instructions with regard to this, the eligibility criteria, where the turnover has to be 29 crores, 29.40
crores.
40 crores. On earlier tender, it was only 8 crores. 8 crores and odd. It is a submission of the land council for the petitioner that only to
That too.
facilitate a particular
8 crores for 1 year in 3 proceeding. Now for all the 3 years, we have to show 29.40 crores.
Oh, it is 8 into 3. 8 into 3, that's for 1 year.
No. They claim earlier bid was insofar as 8 crores in any of the 3 preceding years. Here now they are prescribed 29.40 crores for all the 3 years preceding.
Every year you need to have 29 crores turnover. Each year.
Average financial turnover.
So and so.
My lords,
Only
what is stated?
As far as that clause is concerned, we'll
My
find
lords,
out.
my
Remaining,
lords,
I'm convinced.
my lords, what is?
Lords,
may I read,
insofar
my
as
lords?
condition number 4 also, my lords, KPMA registration, my lords, not
With regard to
required.
condition
My
number
lords, may I
4,
kindly say?
condition number?
My lords, 5 also, my lords, because they specified,
My lords,
they
condition number
specified 3
2.
months, my lords.
My lords, condition number 2, may I read again, my lords? The bidder should have a minimum average financial turnover at least 29.40 crores in the preceding 3 years, not for the, my lords, the average.
That earlier it was 8.9.
Yes.
So by 8.8 has become 29 now. There should be something when you are happy with their services, what they have done.
Yes.
Remaining other clauses with regard to that medical profession and that.
KPME registration,
KP?
absolutely, KPME,
registration.
Karnataka Private Medical Establishment Act.
The AGA shall get instructions, list the matter on Monday.
Lords, in the
Today is
meantime,
the
Lords,
last
let
day
them
for-
not precipitate the
My lords,
tender.
today is the last date, my
Go on.
lords.
If it is, we will anyway, we will set aside.
My Lords may kindly make it clear, my Lords, in the order at least.
What is that?
My Lords, that if at all these conditions are found to be unreasonable, subject to, my Lords, the result of the
Subject to my
petition and
instructions,
then
I will take instructions and
the-
submit.
The further process is subject to the result of the writ petition.
Please.
Yes. Yes, next.
Seal number 47.
My Lords, 45, 46, 48, 50, 51 and 52.
Yes,
All are
47,
50, 51, 52.
52.
47.
Seal number 47.
Lords,
Seal
please.
number- Pachapure.
Defendants writ petition, my lords. Respondent plaintiffs, my lords, they have filed a suit for declaration of title and injunction. The mother of the plaintiff, my lords, and husband of defendant number one are siblings, my lords. The case of the plaintiff, my lords, is that they are the owners. They had put the defendant in permissive possession of the property for a period of 3 years from 1988. And then in the year 1991, defendant has taken back the possession of the, has given back the possession to the plaintiffs, and they continue to be in possession, and they sought for injunction as against these defendants. In the year 2015, my lords, this defendant has filed her written statement. In that, my lords, one of the defense taken is a plea of adverse possession, my lords. And my lords, in 2016, issues are framed. Both the parties, my lords, have led in evidence. When the matter was set down, my lords, for arguments, the plaintiffs have filed an application under Order 6, Rule 17.
No, suit is which year?
Pardon, my lords?
Suit is which year?
2015, my lords.
When did they file this application under Order 6, Rule 17?
Now, my lords, in 2025, my lords.
What is that they want to amend?
They want to insert a paragraph regarding possession, my lords, and also a prayer for possession. Earlier, their suit was for declaration and injunction, claiming that they are in possession all through, my lords. Now, we had taken a defense of adverse possession. Now, my lords, to circumvent that pleading of ours, now they want to insert a prayer for possession, my lords. And that application has been
Recovery of possession.
for recovery of possession. That application has been allowed, my lords, and filed after, my lords, 10 years, my lords.
Let's see.
Annexure A, my lords, is the impugned order, my lords. Page 25 onwards is the finding, para 12, my lords.
Let's see the affidavit that is filed under Order 6, Rule 17.
That is annexure E, my lords. Page 46 is the application.
46.
Page 46, my lords.
Where is the affidavit? Yes.
Proposed amendment, my lords. The defendant is in permissive possession up to the year.
Page 48.
Please, my lords. Para 2, my lords. Basically, the plaintiff number 1 and my deceased father, being full-blooded brothers, filed above suit for declaration and injunction based on the registered sale deed dated 17/4/1963. The defendant is contending that she is the owner to the extent of 4 acres by virtue of a gift deed dated so and so. Contrary to this contention, defendant also contending that she perfected title by virtue of adverse possession. The permissive possession granted by my father and plaintiff number 1 is misused by the defendant and taking advantage of the record of rights in the name of the defendant to the extent of 4 acres, trying to lay false claim and falsely contending that she is in possession of the property. Hence, if the honorable court comes to the conclusion that defendant is in possession of the suit property to the extent of 4 acres.
The petitioner is the defendant in the suit. The respondent has filed a suit for declaration and injunction. The suit is of the year 2015. Now, when IA is filed, seeking, an IA is filed under Order 6, Rule 17, seeking recovery of possession. And the trial court, by order impugned, had allowed the same. And counsel submits that the IA that is filed is barred by limitation. And that apart, the petition, the respondent cannot take contrast stance when it is a case of the defendant, plaintiff, that they are in possession of the property. Question of recovery of possession would not arise. Considering the submission, there shall be stay of all further proceedings pursuant to the order so and so. The petitioner is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 10th of February, or else a stay granted by this court stands vacated.
Please, my lords.
In addition, issue notice to the respondent.
Please, my
Is
lords.
49.
Seal number 48 urgent, seal number 49. Saurabh Hegde.
Petitioner is a recreational sports club, my lord. Now, petitioner is conducting recreational activity, indoor sports game. My lord. What happens is, every time a new police officer comes to the area, Lord, interferes in my premises.
What do you do?
Lord, that's the reason, my lord. Totally, there were more than 15 matters, my lord. All batch matters have been disposed, my lord. Annexure D1 to D4. I have attached 4 judgments, my lord, of the similar kind, my lord. In fact, it starts from annexure D, page number 17 onwards, my lord.
Coming for first time, I take instructions I will take.
In fact, my lord, this was also disposed on the
We'll
same.
take it up on Monday and let him get instructions. We'll take it up on Monday, let him get instructions. At the request of Learned AGA, the list is matter on Monday. Get instructions by the time, not Monday, Tuesday. Yes, next.
50, 51, 52 urgent, seal number 53. Basavanagoda T.
For the petitioner, this matter, lords. But the petitioner hearing of the defendant number 2 before the trial court. Though not the respondent, contending respondents have filed a suit for declaration and permanent injunction with respect to the suit and properties. After service of notes, the defendant number 2, as well as the defendants have filed a counter written statement, as well as the counter claim notes. Now, the petitioner is filed an application.
What is the counter claim?
He is the absolute owner of the declaration and injunction with respect to the.
You also sought.
We sought, because on the basis of the registered sale deed executed by the vendor, in the year 1972. On the basis of that, we filed a.
What is the present IA?
Present, I filed an application for amending some written statement and as well as the counter claim note. That is the reason that trial court has rejected my prayer. Only without considering the facts that the amendment sought is very much necessary to adjudicate the matter.
Let's see that order.
On the basis, on the ground that the trial court.
Suit is of which year? 2014.
14, but it's very much near because some partition deeds came to be some portion of documents came to be relayed, but very recently we traced out that is the reason after on the basis of that document we filed an amendment of the plaintiff.
So to cover the latches.
It's not cover the latches marks because the.
Let's read the reason.
The contending respondents have.
Where is your affidavit? Let us read your affidavit.
My application is not, sir.
At page number 68.
May I read notes? May I read the affidavit notes? May I read the affidavit of the application? Yes. But your also may permit me the application, read application notes. Page number 66 minutes, Lordship.
No, 66 is the application. Affidavit is at 68.
Oh,
that we will read. Affidavit will read.
It is very relevant portion, because they are themselves.
No. First of all, you will tell what it is in your affidavit. We'll read your affidavit.
Please. But second para onwards, notes. The plaintiffs have filed this above suit for declaration of title of the permanent injunction over the suit property against me and the defendant number 1. I have filed the written statement and also the counterclaim. Subsequently, already I have filed one certified copy of the registered gift deed dated 30/7/2020, which is executed by one Banakar Parvathamma in favor of her only daughter by name Banakar Suvarna, who is the wife of the plaintiff number 9 in the above suit. And also, I have filed the RTCs of the land bearing survey number 256/B, extent 3.46 acres, and it's RTCs of the OD survey numbers and survey number 266B, extent 7.20 acres, and its RTC of the POD surveys numbers. Both are situated at Hagrigudali village of Chigiteri, Hobli.
So now you have sought the counterclaim now.
Please, I filed a counterclaim also.
In a suit of 2014, you want a counterclaim now.
I sought written statement as well as the counterclaim amendment notes. That is the reason.
No, please come to the order now. I have seen that.
Next paragraph is very much relevant notes in affidavit notes.
I have read that. If you want, you can.
Because they have partitioned. They sort of made some transactions with respect to the other properties. They mentioned the schedule as western side. My property is there. Your lordship may kindly see. Page number, next para, the plaintiff number 5 to 5, 6 and 9 and the sons of Banakar Basappa and Banakar Channabasappa have been made some transactions on the both side, both lands bearing survey number 256B and to the extent of 346 acres and survey number 266B to the extent of 7.20 acres from the year 2001 to 23. But the plaintiffs and the said sons of Banakar Basappa and Banakar Channabasappa have not made any transaction on behalf of on the suit scheduled land from the year 1968 till to filing of the suit. Since 45 years, they have been silent on the suit scheduled property. The said Banakar Basappa and Banakar Channabasappa were brothers of said Banakar Hanumantappa. Next month. They have admitted their in their schedule, they saying that western side the property of respondent number 9 is situated in their schedule notes. That is the reason notes the court has without trial court without considering the very said fact notes they rejected my prior notes. That is the reason. Only the court has considered that there is a delay in filing the application. But it's very well the amendments we sought in their amendment is very much necessary to adjudicate the matter notes on merits. That is the reason only I'm requesting your lordship to grant an interim order.
I'm not convinced.
Your lordship, it's very amendment is very necessary to adjudicate the matter notes. That is the reason. On the basis of the revenue particular documents, the sale deed in the year 19.
They are which year?
Not 19.
The documents which you are referring to.
Very recently, I traced it. 1972.
No, they are marked already in the evidence.
I produced the same, but
when was that? You have already let in evidence. After letting in evidence, you want to.
The matter is posted for evidence not. That is the reason only.
No, defendant, they are marked as D1 to D4.
Some portion of document. No yes. Evidence. Cross-examination DW is DW2.
The document is of the year 2020. No. Those documents are of the year 2020.
That is the reason not. I sought for amendment. The cross-examination DW is pending before the trial court.
The present writ petition is filed. Questioning the order dated. Questioning the order passed in I number 13 in OS number 89 of 2014 till 6 November 2025. The petitioner before this court is the defendant number 2. The respondent herein has filed a suit for declaration of title and for permanent injunction. In that, the defendant has filed an IA. The suit is filed in the year 2014. In that, I number 13 is filed under Order 6, Rule 17 of CPC, seeking to amend the written statement and the counterclaim filed by him to insert the written statement under the counterclaim. By order impugned, the court had dismissed the IA that is filed. While dismissing the IA, the court has observed that the defendant has pleaded altogether a new facts. An amendment is sought in the written statement and the counterclaim. The suit was filed in the year 2014 and also written statement and counterclaim was filed in the year 2014. In the written statement, plea of earlier partition is taken and so also the defendants have claimed right over half of the suit property. Suit is for declaration and permanent injunction and already evidence is almost completed. When the case was posted for further evidence of DW2, this application has been filed after 11 years and no reasons are assigned for delay in filing the written statement. The court observed that amendment is to introduce a new pleadings which are belated and are not tenable. The court has also discussed the judgments of the apex court in that regard. And it is observed that under Order 6 Rule 17 of CPC, the court has powers at any stage of the suit to permit either party to alter or amend the pleadings. However, such amendment must be necessary for the purpose of determining the real questions in controversy between the parties. No such amendment can be allowed after the trial has commenced unless the court comes to the conclusion that, in spite of due diligence, the party could not raise the matter before commencement of trial. But in this case, amendment would take away the right already accrued to the adversary. Amendment is also post-trial. Hence, the court had dismissed the IA. Learned counsel appearing for the petitioner D2 submits that the amendment that is sought by the petitioner is very much required to adjudicate the disputes between the parties. Even if the amendment is allowed, the nature of the suit will not be changed and the refusal, the nature of the suit will not change. It is submitted that the Honorable Apex Court time and again has observed that the court cannot apply a hyper-technical view while allowing the amendments. It is submitted that the amendment sought by the petitioner is only to clarify the existing defense and counterclaim pleas, and no prejudice will be caused to the other side. Further, the amendment that is sought is necessary to bring on record the necessary facts which will enable the court to resolve the disputes between the parties in a better way. The court, without considering all these aspects, only on the ground of laches, had dismissed the petition and the order impugned needs to be set aside. Next para. Having heard the counsel for the petitioner, there is a material on record. The suit is filed with the respondent for declaration and injunction. There's a suit of 2014. Already the petitioner has sought for has filed a written statement and also sought for a kind of counterclaim. Now it is a case of the defendant that he had a copy of the certified copy of the registered gift deed dated 30/7/2020, which is executed by one Bankar Parvathamma in favor of her only daughter by name Suvarna, who is the wife of plaintiff number 7. And the petitioner defendant has filed the RTCs of the land to an extent of 3 acre for 3.46 acres. And its RTCs of the Podi survey numbers and our survey number 266/B, extent of 7 acre 20 guntas, and its RTCs of the Podi survey numbers. Both are situated at Hagari, how do you spell it? Hagari Kudihalli village. Of village, Hobli.
Hagare Gudihalli village.
The plaintiff number 5, 6 and 9 have made some transactions on both the lands from the year 2001 to 2023. But the plaintiffs and the second sons of the Bankar Basappa and Channa Basappa have not made any transactions in the suit schedule property from the year 1968 till the filing of the suit. Since 45 years, they've been silent on the suit schedule land. And the said Bankar Basappa and Channa Basappa were brothers of the said Hanumantappa. It is stated that the documents filed by the petitioner are corroborative evidence with the documents filed by him already marked, that is exhibit D1 to D6. Hence, the amendment of the written statement and the counterclaim is very much necessary. This court has perused the affidavit that is filed and the amendment that is sought to be and the amendment to the pleadings, and by way of the amendment, what are the pleadings the defendant wants to insert. The court, as after the amendment to the CPC, after the trial, if the IA under Order 6 Rule 17 has to be allowed, the burden lies on the party to establish before the court that in spite of due diligence, these facts could not be brought to the notice of the court. Admittedly, even the document that the petitioner is referring to are of the year 2020. Suit is of the year 2014, and this IA came to be filed on to be filed on 22/4/2025. The, when, after the evidence of the plaintiff is completed at the stage, at that stage, the defendant had filed this application by introducing the new facts, and according to him, for the better appreciation of the facts involved in the case, this amendment is necessary. That is not the purport of an application under Order 6 Rule 17. And if the court, as the court has rightly observed that by allowing this application, lot of prejudice would be caused to the plaintiff, and it would amount to taking away the valuable rights that are already accrued in favor of one party. This court is of the view that the trial court has rightly considered all the facts and rightly dismissed the application, and this court finds no reasons to interfere. Yes, after lunch. Huh?
39, it is urgent, Lord. I seek to withdrawal, Lord.
What is that?
Serial number 39, auction method, Lord.
39.
39. The past or urgent, I am not aware, Lord. It may, I permit to withdraw, Lord.
39, a memo is filed seeking to withdraw
My
the
lord.
writ petition. The same is permitted and dismissed as withdrawn.
My lord, second list to 23 page number, serial number. Oh, please transfer second, other, this,
23.
23 number.
Second list, serial number 23.
It is
Party
transfer
person
second,
was comfortable in
other,
arguing in English. Let it be after obtaining the necessary orders placed before the other court.
Interim order is still today, my lord.
Huh?
23 in both the matters, interim order is there.
If the interim order is there, extended it in the next date.
Please.
ಇದು 39 ಇವ್ರಿಗಾಗಿದೆ ಇಮೇಜಿಗಾಗಿದೆ ಇಸ್ಕೊಂಡ್ ಮಾಡಿ
ಈಗಿಲ್ಲ ಮಧ್ಯಾಹ್ನ ಊಟ ಮಾಡಿ ಬಂದ್ಮೇಲೆ ಟೈಮ್ ಶಾರ್ಟೇಜ್ ಐತಿ ಮೇಡಮ್. ಊಟ ಮಾಡಿ ಬಂದು ತಂದು ಕೊಡ್ಸಿ ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದು. ನಾನೇ ಸಿಕ್ ಮಾಡಿದ್ದೀನಿ ಮೇಡಮ್. ಮೇಡಮ್ ಫೈಲ್ ಇದೆ ಅಲ್ಲ ಹಿಂದೆ ಇಟ್ಬಿಡ್ತೀನಿ, ನಾನು ಕೊಟ್ಟು ಬಿಡ್ತೀನಿ. ಅವ್ರು ಮೇಡಮ್ ಇದ್ದಾರೆ, ಹೆಂಗ ನಾನು ತಗೋಬೇಕು ಇವ್ರು ನೋಡ್ತಾರ. ಅದೇ ಎರಡ್ ಮೂರು ಅಲ್ಲಿ ಇಟ್ಬಿಡ್ತೀನಿ, ನಾನು ಕೊಟ್ಟು ಬಿಡ್ತೀನಿ. ನಾನು ಅದಕ್ಕೆ ನಾನೇನ್
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಡಿಸ್ಕಷನ್ ಮಾಡ್ಬೋದು
ಅಷ್ಟೇ
ಮಾಡ್ಬೋದು ಅಂತ ಮೊದಲ ಟ್ರಾನ್ಸ್ಫರ್ ಮೀಟರ್ ಅದಾರ ಟೆಂಡರ್ ಮೀಟರ್ ತಗೊಂಡ್ಮೇಲೆ ತಗೊಂಡ್ರಿ
ಬರೀ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಬಿಡ್ತಾರ ಅಂತಂತಾರ.
ನೋಡೋಣ ತಡ್ರಿ ಮತ್ತೆ ಫ್ರೆಶ್ ಇದ್ರೆ ತಗೋಬಹುದು ಫಸ್ಟ್ ಮುಗಿದ ಮೇಲೆ ತಗೋಬಹುದು.
In consideration of the facts and the circumstances, the entire action by the respondent is vitiated.
There are three findings.
That's very unfortunate that the officer without application of mind, contrary to your own circulars.
Lords, I take notice for R2.
What that notice says, read, present, where is that impute notice?
Annexure A, my lords.
That is in Kannada only for, they have fixed the date on 19/12/25 at about 4.
What
has
is
been
the petitioner?
Petitioner is a retired employee, my lords. He was working with he was working as
Retired
an
RTO.
RTO,
Regional Transport Officer.
Officer, my lords.
Next is LRs will also be issued notice.
This is issued by, my lords,
Tell
the,
your officer, at least your first respondent, there
Yes.
should be some application of mind before doing anything.
Moreover, my lords, this notice is without jurisdiction.
First of all, your own circular says anonymous complaint shall not be considered. Why are you considering and issuing notices? Please come.
so I take notice for R2.
R,
R2. Respondent.
don't appear.
C. Jagdish appears for R1 and R3.
So and so, 2 and 3. So AGA
One,
takes,
my lords, 1 and 3, C. Jagdish.
you takes notice.
I take notice for our respondent number 2, Deputy Commissioner.
Respondent number 2, so and so takes notice. Then counsel for the petitioner submits that the petitioner was granted his caste, the certificate in the year 2010. The same was questioned by a third party.
1984.
Huh?
Caste certificate was issued
On
in
1984. In the year 2010, when a complaint is given, the same was, the SCST commission has held the same, and an order was passed on 16/4/2010, wherein they have imposed cost for ₹1,000 on the complainant. Again, in the year 2020, another anonymous complaint is given, questioning that the petitioner has approached the
Karnataka State Administrative Tribunal.
Karnataka State Administrative Tribunal at Belgavi, and by order dated 21st June 2023, the notice dated 11/3/2020 is set aside. And the court and the administrative tribunal has taken into consideration the circulars that are issued by the government from time to time, where time to time, and also the earlier litigation. It is submitted that now again on an anonymous complaint, the respondent number 1 has issued the notice. Next para, it appears that the respondent without application of mind has issued the notice. Why the first respondent is considering an anonymous complaint, and why he has issued a notice, the respondent shall file his objections. They shall be, what is the intermodal you are seeking?
Stay of operation of the
There
impute
shall be
notice.
stay of operation of the notice dated so and so. The issue notice to respondents 1 and 3.
Much obliged.
Yes, next. What is dispensation?
My lord, type copy is my
IA
lords.
number 1025 is filed for dispensation type legible copy of annexure C, K and L. Dispense, IA is allowed. IA 2 of 26 is filed for dispensation of the petition of CC of the annexure J, dispensed with.
Much obliged.
This 57.
Number 57. Rundappa Malli.
Plus the petitioner seeking mandamus directed to not to interfere the respondent authority to, it is pertain to recreation club matters.
It's a case of recreation, similar to serial number 49.
Let me just look at it. I'm not able to hear what he said.
My lord, similar to serial number 49.
Directing the respondent authority which permits the petitioner to open the club
Yes,
and
this
to
is,
continue its day-to-day activities as per the bylaw, and not to insist upon the petitioner to obtain license for the play of caroms, chess, rummy and booty, etc. Either under the, there must be some covered orders for this.
Please, number of petitions are allowed by this honorable court.
Where is that?
serial number 49 is a similar matter in this same list, 49.
Which you have taken it to.
Yes, I have taken
Is
notice.
this matter on Monday?
Monday.
Along with what's the number gives so
Yes.
that both will come.
Please.
That 49 along with.
49 mullahs. 14. Matter is posted on Tuesday mullahs.
On Tuesday. Yes.
Preliminary hearing, B group matter, seal number 58 urgent, seal number 59, KL Patil, Chetan Munwalli.
The petitioner is the owner of the property, my lords, which the property without acquisition was acquired for the purpose of widening of the road, my lords.
Let's see the prayer, where is it?
Prayer, my lords, at page number 12.
Respondent to determine and pay compensation rent payable to the petitioner
Yes.
from the date of taking over portion of the land from the petitioner till date of payment, and the said additional amount shall be paid along with the compensation.
Yes.
What is this?
Yes. The property, my lords, portion of the property was acquired by the respondents, my lords, for widening of the road. For that, there is no acquisition proceedings and no compensation was paid, my lords.
When was this when did they acquire?
They acquired, my lords, during 2016, my lords. Prayer starts from page number,
From 2016?
page number 10, prayer starts, my lords.
Huh?
Prayer starts from page number 10, my lords.
11.
To conduct necessary survey of the property.
Property and
To identify and ascertain the exact
exact,
extent.
sir.
After conducting the survey, taken over, utilized for the purpose of widening.
Please.
Issue mandamus to determine and pay compensation.
Some It's in,
What are your
similar
instructions?
set.
I'm sorry, my lords.
What are your instructions?
Lords, my instructions, my lords, since from 2016 till date, my lords, he has not approached. Only in the month of, my lords, September 2025.
Is it the fact that you have acquired his land?
My lords, that we have to ascertain. That, my lords, what had happened is,
Because as far as these aspects of concern, latches will not come in the way because your property is his. You have acquired the property, no dispute on that.
Yes,
So there are no third party rights accrued in this. So you are liable to pay the compensation.
that is,
to him.
he, my lords, for the first time, he approached a corporation only, my lords, on 17/9/2025.
79?
2025.
Let them consider the representation.
Yes, my lords.
Consider similar set of fact, but not.
Those are different.
Problem is this, there can't be any similar set of facts. We have to ascertain the fact from him whether your property is used for them or not. They have
No,
acquired
that's why
it
I
or
was
not.
requesting them to consider my representation and conduct a survey, my lords. If they have conducted a survey, my lords, they will come to know that whether what extent of land was they have acquired.
I think it's better, let them come up with their objections so that the thing.
They have
is-
filed objections. I have filed objections insofar as delay and latches are concerned. Insofar as consideration of representation, identification of the property and other things.
He has raised several grounds, then you must have answered to all those objections.
My lords, only, my lords, he has raised only grounds, my lords, his property has been utilized.
Have you accepted that or not?
That aspect, my lords, I have not addressed.
You have to be
I have to-
specific
I
in
have to-
your,
I was
the
supposed.
respondent shall place before the respondent shall file an affidavit before this court, whether the land belonging to the petitioner was acquired for the road widening process or not. This is matter on 2nd of February.
Please.
Seal number 60.
My lords, another week's, my lords, another
List the matter on, when did I say? February?
2nd February. my lords.
February 9th.
Please.
Yes.
Seal number 60, Chetan Munwalli.
Right, 6 weeks accommodation to file objections, my lords. I'm appearing for the contesting party. I need to file objections, my lords.
What is this?
Land reforms, my lords,
Land reforms.
tenancy rights were,
LR is coming for me.
since
Oh.
I'm disabled.
Okay.
My lords, tenancy rights were sought by the contesting respondent's father.
These are all in Kannada. That's why this LR is not before me.
Yes, my lords.
Is this matter before the other bench?
My lords, again, my lords, some other.
It will go to some other judge.
Please.
The matter
Line.
is placed before this court as the same as not before the judge who is having the LR roster, as all the documents are in Kannada. Let it be listed before before some other court.
It's interim order granted earlier.
Intermod earlier granted. Intermod is there in that.
There is that.
Intermod granted earlier is extended till then. Yes.
Please, my lords.
Seal number 61.
This matter may, I'm appearing for the respondent in receipt. Matter may be taken on 20th, my lord, since I need to file objections, my lord.
What is this about?
This is, my lords, by a law student seeking permission to, law student, my lords, is the petitioner is a law student. Petition is filed seeking for permission to, my lords, appear for third semester's examination, which by virtue of interim order, my lords, is be permitted to.
Why you are before this court?
Then a violation of regulations, my lord, since he has not completed the, so all clear all the subjects as per the regulations, my lord.
Then why the court should interfere?
My lords, she may be permitted to, my lords, write the,
When you are not eligible to appear, why should we grant permission? Now what will happen till you complete your law? Everything will done by the High Court. Permission to appear, then declaring the result, then giving you the certificate.
let's ask
So
for the,
that's why there should be, the court shall not interfere in these kind of matters. When you're not complying, you're not complying. You have done it at your, let's see, what is that, what is the crux of the issue?
let's may have it day after tomorrow, I'll
Yes,
convince
yes,
you.
day after tomorrow.
Obliged.
Not day after tomorrow. This is matter on 19th.
Please.
Obliged.
Yes, next. What is this further hearing? Oh, tender.
This was reserved by your lordships because of the other two matters. It was.
No, no, no. The other day he has come. He said that when you was referring to the other matters, some submission he couldn't make.
I'm sorry, I was not aware of.
It is there. I thought I'll hear him.
Yes, yes.
Only without troubling your lordship, only my lords, my submission that the final bid, lordship has find that I am also my lords and confused. It is also in accordance with the circular.
Let's look at it. Let's look at the dates and all.
Yes. Synopsis my lords I have filed in 110045. 110045.
45, 63, give his.
63.
Yes.
63.
Please.
I don't think it is 63.
Lords.
63.
Please, lords, 110045.
No, page number,
Page number, minutes. A synopsis, a separate synopsis of 5 minutes on 8th of January. 20. Wherein minutes, as I have submitted, let's see, lordship may find that details of Miller's tender in Miller's my impleading application along with they have not produced Miller's that copy. That is the part of the Miller's notification. Annexure R4 in this matter only. Wherein Miller's find the details of Miller's page Miller 17 impleading application R4. Last page Miller's page 23. Timeline Miller's wherein lordship may find bid valid time period is 90 days. Page 23.
90 days.
Please. Last date and time submission of queries clarification 29/8/2025. Last date and time of receipt of tender 18/9/2025. And time and technical bid open the 20th/5/2025.
29/2025.
20th 9, please.
29.
It is Miller's, while looking to the Miller's along with the circular. First Miller's opening of technical bid within 48 hours, that is in accordance with law. Circular Miller dated 29/11/2021.
Yes.
Thereafter Miller's evaluation of technical bid 30 days. That is also in accordance with it. Now, my lords, financial bid from that date, my lords, that will, my lords, 20th-9/2025 is the, my lords, technical bid. Thereafter, my lords, 21/11 is the, my lords, evaluation of technical bid. 21/9 technical bid, opening of technical bid. 21/10/2025 evaluation of technical bid. Thereafter, 31st day, my lords, that is, my lords, financial bid. It will, my lords, come to 26/11/2025. In between, my lords, 24/11, there is the interim order. So that, for that reason only, my lords, the process of tender is pending. There is no, my lords, violation by the, my lords, authority or by the, my lords, any persons concerned to the, my lords, tender.
Yes. Please file your, the written submissions.
Yeah.
Yes, all the matters resolved.
So what is not argued by the government? It is not the case of the government at all.
Which one?
The tender inviting authority doesn't say all these things.
To let him, that's his submission.
Yes, yes.
Earlier matters also passed over matters along with this reserve. In that interim order, if any, till such time.
And in all, my lords, 90 days, till today, my lords, along with the synopsis, my lords.
No, please file your
75. Please.
submission.
Please.
Yes. Yes, next.
Public.
Shall
Final hearing matter, seal number 64, Harmantar Lathur, Tipati, list 1.
Who appears? No representation list this matter in the month of March. 65.
Seal number 65, Madan Mohan M. Kannur.
This appears for the appellant, your lordship.
I am appearing for respondent number 4, my lords.
And in this, your lordship, it is a claimant appeal. That, your lordship, in this case, your lordship, I sought for enhancement and also for shifting of the liability upon the respondent number 2 and, your lordship, only on the ground pay and recovery, your lordship. But I am not much concerned about the enhancement, your lordship. Pay and recovery, your lordship, may order.
On what ground?
That no license, your lordship.
Please come to the liability.
Yes. Para, your lordship, can you see the tribunal has given a finding in para number 87 and 89. For a moment, para number 90 may kindly see, your lordship. In page 59, the trial court.
There is no DL.
Yes, no DL.
I am appearing for respondent number 4, my lords.
We
are the formal party, my lords. Respondent number 2, Oriental Insurance Company.
Which is the insurance company?
Oriental Insurance Company. Respondent number 2, my lords.
But it is the liability against your lordship, the negligence on the part of the
1 minute. This is 65.
65 lordship. 2 insurance companies are there, 2 vehicles are involved.
No, already somebody has filed wakalat.
Yes, filed wakalat, your lordship.
Who is the counsel?
That your lordship. Holyward.
Seal number 65.
Heard the land counsel for the appellant. No representation on behalf of the respondent. List this matter for judgment tomorrow.
Please, ma'am.
30. Seal number 66, Santosh B. Rao. Santosh has something.
Claimant's appeal for enhancement as well as the shifting of liability on the insurance company. My lord.
On what ground the liability is fixed?
My lord, on the ground that the driver of the offending vehicle was not holding the valid DL.
Yes.
I appear, the owner, Mande is appearing.
What is happening? Why the
Yes, ma'am.
respondents are not appearing?
My lord,
Mande is in VC.
So the
I am representing the insurance company, my lord. Respond number 2.
pay and recover.
Pay and recover, my lord. Yes.
Yes.
My lord, enhancement little bit scope
Where
is
is
there.
where is the table? Come to the table.
Please. At synopsis, my lord, I have given all the
Table, it's there. Table is there. Come to page number 20. Internal page 20.
regarding the loss of dependency, my lord, income has been considered
Which year
only,
is the accident?
my lord, the accident of the year 2014,
How much was taken as income?
6,000, my lord,
How much should be taken?
7,500.
500. What is the age?
Age is, my lord, 30 years at the time of accident.
30 years.
Yes, my lord.
How many are the dependents?
My lord, 5 dependents, my lord.
5 dependents.
5 dependents.
One-fourth has to be deducted.
Please.
7875 into 12 into what is the multiplier?
17.
6. No?
It comes to 16 lakh 6,500. You said 5 are the dependents.
Yes, ma'am. 2 lakh.
5 into 40.
My lord, future prospects, my lord.
It's coming to 18 lakh 72,500 against 10 lakh 13,000.
Please.
Yes, it's coming to 18
Yes,
lakh
ma'am.
72,500.
Yes, my lord. Please, my lord.
Yes, please come. Agreed with award passed in MVC number 2572 of 2014 by so and so, dated 1st July 2023. The claimant is before this court on seeking enhancement of the compensation and also questioning the liability fixed on the owner of the vehicle. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the death of the deceased in the road accident. According to the petitioner, according to the claimants, the deceased was aged 30 years and earning 1 lakh per month per annum from agriculture and more than 10,000 per month. The tribunal has taken the income at 6,000 and granted the compensation as per the table given below at paragraph number 22 extract. When it comes to the liability, as a driver of the offending vehicle was not having a driving license, the liability is fixed on the owner of the vehicle. As a owner of the vehicle has failed to enter into the
No,
witness.
owner of the vehicle himself was driving, my lord.
As he has failed to, the owner of the vehicle was driving the vehicle and he was not having a driving license and he has failed to enter into the witness box. The liability is fixed on the owner alone. Land counsel, owner alone, next para. Land counsel appearing for the claimant submits that this accident had taken place in the year 2014. The court, at least as per the table, as per the table fixed for the legal services authority, ought to have taken 7,500 as income, but taken 6,000. It is submitted that the petitioner is the deceased is a third party, and in the light of the settled law in Swaran Singh's case, the tribunal ought to have applied the principle of pay and recover, and ought to have applied the principle of pay and recover. Next para, the learned counsel appearing for the insurance company and the counsel appearing for the owner of the vehicle submits that the court has rightly, considering all the aspects, had rightly passed the award, had rightly granted the compensation, and there are no grounds to interfere. Learned counsel appearing for the insurance company does not dispute the fact that in the light of the settled law, the principle of pay and recover will apply. Next para. Having heard the counsels on either side, there is the material on record. First, coming to the aspect of the.
My lord, it may kindly be taken, my lord, that I have argued that the judgment is correct as far as the liability is also concerned. and your lordship may
You
pass a liability
submitted
on the
that the
insurance.
court has rightly fixed a liability on the owner of the vehicle as he has failed to, as he is not having a driving license, as well he has failed to come before, enter the witness box. Next paragraph.
Yes, madam.
First, coming to the aspect of liability, the driver of the offending, the owner of the offending vehicle was not, owner of the offending vehicle who was riding the vehicle was not having a valid driving license in spite of the same. In the light of the settled law, as per the law laid down by the apex court in Swaransingh's case, the principle of pay and recover will, pay and recover applies. As such, the insurance company shall pay and record the same from the owner of the vehicle. Next, coming to the compensation. This accident had taken place in the year 2014. Though there is no evidence on record, this court is taking the notional income at 7,500. The age of the deceased is 30 years. 40% future prospects would come to 3,000. Then it is 10,500. There are 5 pendants. 1/4 has to be deducted towards the personal expenses. It comes to 2,625. Then his contribution to the family would be 7,875 into 12 into 17. Under the head of loss of dependency, he is entitled for an amount of rupees 16,06,500. Under the head of consortium, 5 into 44, 2,20,000. And funeral expenses, 36,000, reduce it. In the 36,000, and in the light of the law laid down in vehicle houses so-and-so, 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 18,72,500. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 10,13,000 to 18,72,500. The enhanced amount shall carry 6% interest. The insurance company shall pay the compensation and record the same from the owner of the vehicle. You should pin it.
In the same
Yes,
proceedings, your lordship.
Yes,
In the same proceedings, my lord. To recover in the same proceedings, so that directly EP can be filed
the same proceedings.
in the same proceedings. Yes.
Yes, next.
Seal number 67, adjourn.
Yes, pass over, madam.
Pass over matters. List 1. Seal number 30.
Number?
Seal number 30, 30. Preeti Shashank.
Why is it passed over in the morning? Huh? No, not this one. It's an insurance, 30 you are saying. 30, it's an insurance company matter. I think she wanted to get the calculation. The
Connected, the 69 and another can connect with the.
It is submitted that the insurance company is on the ground of quantum. The court, without considering all the aspects, have granted the compensation on the higher side. Considering the same, they shall be stay 50%, 4 weeks. Yes, next, no
Seal number
permission to withdraw.
44. 44, pass over matter.
Please. I don't know, the problem is, my lord.
Huh?
Now the problem is, if I challenge this order before the state commission, my lord, I have to deposit 50% of the amount, my lord. There is no fault on my side, my lord. I'm an ex-employee. I'm not in a position to now.
Have you contested the matter before the judge?
That's what, my lord. The notice was not served to me.
Served to whom then?
My lord, in the petition complaint, my lord, they showed my address as a society. So the notice was not served to me personally.
So
Already liquidator is appointed in this matter, my lord.
Huh?
Already liquidator is appointed in this matter, my lord. Regarding that society.
Your name is Raju. Where
Please.
are you shown as a party to this?
Pardon, my lord.
Please come to the cause title before the District Consumer Commission.
Opponent number 3, my lord, at page number 48,
It's a credit society.
please, represented by General Manager Raju.
You're not in your personal capacity,
No, my lord.
isn't it? You're not in arrayed as a respondent in your personal capacity.
Personal capacity.
So why are you filing the writ petition in your personal capacity?
My lord, my lord, my annexure,
What are the
annexure D, my lord, I have already resigned from the society, my lord. I gave my resignation.
Oh, your liability, you are as a Darden secretary.
But in operative portion, my lord, they personally made me liable, my lord. For that reason, I came before this.
Where they said, come to the order.
Now, non-bailable warrant has been issued by the.
Opponent number 2 and 3 are jointly and severally liable.
Please, but my lord, the non-bailable warrant is issued against me, my lord, now.
How can you file a writ petition in this nature? You are a respondent number 2 is a society, not you. Represented by so and so means he will not be independently liable.
But my lord,
property, attachment, everything is of the society, not your individual.
But in execution application, my lord, they have initiated against me, my lord. Now the non-bailable.
Let's see that. Where is that attachment?
And
where is that execution? How are you arrayed before in the execution?
Annexure A, my lord. Pardon, my lord. Annexure B.
Page number
26. Order sheet of the execution, my lord. Even the execution application notice also was not served to me, my lord, because it is same, my lord.
All the more reason, first of all, your writ petition has to go because you have no locus to file a writ petition before this court.
My lord, but warrant is issued against me, my lord. In personal capacity only
they will not. Accused judgment debtor, Belgavi Liberal Credit Sohart Cooperative Limited. Nowhere your name is shown. You're only assuming something. Please come.
My lord, at page number 40.
Yes.
That is typed copy of the order sheet. Case called out, complaint absent. Advocate so and so absent. A2 is absent. Advocate so and so absent. Hence issue NBW against R2.
It will be issued. Let the society appear. How are you bothered? No, if they issue a warrant against the society, not against you.
Now police is coming in front of my home, my lord, to arrest me.
Problem of the court. Please understand, there is a procedure. Everything we can't go by like this.
But my lord, if I wanted to challenge the same order, my lord, judgment passed by the consumer.
You don't challenge.
Then that observation may kindly be made.
Should we give that observation? First of all, how can you file a writ petition? Writ petition should have been filed, questioning an order passed by the district commission as arrayed as per the cost title. How did they number this writ petition first? It can't be numbered. Now you have questioned the order passed by the district commission. District commission, the respondent number 2 is the Belgavi Cooperative Society. You are who are you?
I am not no more a manager.
You can't file a writ petition like this.
But my lord, the
please understand.
Only apprehension is that, my lord, now
this is not the way. There is a procedure. You have to follow the procedure known to law. Please come.
My lord, but my lord, now I have to. This is not the only case, my lord. There are n number of.
That's what I'm saying. You have to go before. If you are not, you are no more so and so. Go to the court and tell the court, I am nothing. I am not the president. I am not the secretary. You please, I am not a right person. Please implead the person. That application you can file before the court. If you are not concerned with the society now, the present writ petition is filed.
At least liberty may be reserved, my lord, to.
Liberty will be given, but the present writ petition is filed, questioning an order passed by the District Consumer Disputes Redressal Commission, Belgavi, in consumer complaint number 2704 of 2018.
My lord, one submission. At least that NBW may kindly be recalled, my lord.
And subsequent initiation of execution proceedings in criminal complaint number 61 of 2024. The petitioner before this court is not a party to the, before the consumer forum. The parties before there are 3 opponent, the opposite parties before the consumer forum. 3 says Belgavi Liberal Credit Sohart Cooperative Limited, Belgavi branch Sonar Gully, represented by its general manager Raju Hosmani. Now the present writ petition is filed by Raju Hosmani as a petitioner. It is a contention of the land counsel for the petitioner that if he has to go before the state commission, he has to deposit 30% of the amount. Further, no notice is issued to him. He is not working in the Belgavi Liberal Credit so and so for the society. And as this order is passed without following the principles of natural justice and without giving an opportunity to the petitioner, he can come before this court. And according to him, the interim orders are passed in this kind of matters by a coordinate bench of this court. It is his case that now the execution arrest warrant is issued and the police are coming to the petitioner's house. Hence, in view of all these circumstances, the petitioner's interest has to be protected. Next para. The writ petition as it is filed before this court is not maintainable. The petitioner in his individual capacity is not arrayed as an opponent in the as an opposite party in the before the consumer court. The society is the opposite party. The petitioner was working as a general manager of the said society, and he was arrayed as a party. Now it is the case of the petitioner that he is no more working, no more associated with the society. In that case, when the society is a party, a person in his individual capacity is not liable to pay any amount. The petitioner could have appeared before the executing court and could have brought to the notice of the executing court that he has nothing to do with the society and he is no more an employee. Without doing all that, or else he could have gone or without doing any of that, the petitioner in his individual capacity cannot come before this court and file a writ petition. This court, on the first ground, cannot entertain a writ petition which is filed questioning an order passed by the District Consumer Forum. Secondly, the petitioner, who is not a party in his individual capacity, cannot file a writ petition before this court. Third, he has an alternative remedy before the state commission, and also he can represent all these facts before the executing court. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies.
My lord, on submission, at least, my lord, to approach the National Commission.
Why state commission you don't want to go?
Pardon, my lord, state
But
commission.
that is available remedy to you.
Relaxation maybe.
No.
My lord, there are a number of complaints, my lord.
No, it is like this. Your society, without coming to the court, at the behest of the society you are doing it. Why are you going around the courts? First of all, go before the executing court and tell that you have nothing to do.
My lord, I am ready to go before the execution court, my lord. But they have issued NBW, my lord. That may be recalled, then I will be able to file an appropriate application, my lord.
Already recorded that. Yes.
Please list 2. Orders matter serial number 1, KL Patel, AGA. Steps.
Yes, why the memo is moved?
I have not moved them.
Who moved it? Who moved the memo? Hmm?
Sorry, by mistake.
Yes, let's see what is the writ petition about.
Yes. The petitioners are the owners of the property, my lord, bearing
To determine the payment of compensation to the
Compensation.
damages with regard to right of way for transmission.
transmission.
When was this done?
It's what,
They will do it before laying the lines.
no, my lords, because in the agreement also, they have not mentioned regarding this matter. Agreements are at page
Who has
number,
laid the transmission lines?
the respond number 2 and 3 have raised the transmission. My lords. 2
Infra,
and 3, my lords.
Aina Renewable Power 6
Power
Private
substation
Limited.
and Messrs. KS Infrastructure,
At whose behest they are doing it?
government, my lords. Even, my lords, the deputy commissioner has came to passed an order, my lords. As per the deputy commissioner orders also, my lords, they are not paying the compensation. We made a representation to that extent also.
No, how will you lay no, before laying it, you don't determine the compensation.
Yes. It's in the present writ
The
petition.
objections, have you filed the objection?
I'll file it.
Objection shall be filed by February 17th, or else the writ petition will be, the orders will be passed basing on the material on record.
Please, ma'am.
Seal number 2, Santosh Bhimane, R.K. Kulkarni.
Done the needful, my lords. I have paid the price.
It's submitted that the needful is done. This is matter after service of notice. 3, this is the matter after service of notice.
The interim order, my.
In all these matters, wherever interim order is there, extend.
Please.
List the matter after service of notice. 4,
Seal number 4,
notice to R8.
Seal number 4,
R8 and R10 returned as unclaimed, amounts to deemed service of notice. Ready?
Let's tomorrow, I'll argue the matter. Short point is there.
List this matter on 22nd of January.
Interim order may kindly be.
Interim order earlier granted is extended. Next 5.
Great.
number 5,
Week's time may be granted, my lordship. I will take,
question mark.
I will take necessary
A
steps.
week's time for taking steps in respect of R1, or else the writ petition shall stand abated as against R1.
Interim order extension.
Then what about 5.1?
Same, my lordship.
5.1,
Same, my
in
lordship.
respect of R1 and R2, process shall be paid within a week, or else the writ petition shall stand dismissed against R1 and R2. Yes,
Seal number 6,
Interim order
Ibn
extension.
Nesargi.
it will be extended. 6, list
lord.
after service of notice. 9, this
Interim
also
order.
after service of notice.
9,
8,
My lords,
My lord,
Seven.
interim order may kindly be extended in respect of
in
serial
all the
numbers.
matters wherever there is stay, it will be extended.
Serial number 6,
It will be extended.
please.
My lord, serial number 9, my lords. We have served upon the
1 minute. What about 8?
8,
8. 8.
8,
Who appears?
Seal number
A
8,
week, a week's
Santosh
time,
Kumar.
a week's time
Time,
for paying process in respect of R1 and R2, or else the writ petition shall stand dismissed against so. In all these matters, wherever stay, it shall be extended. Yes. 9,
my lords for the
Nine.
petitioner. I have served the notices upon the respective councils.
R1 to R7.
Everybody, my lords.
Undertaken to appear on behalf of 11 to 32, your lordship.
On behalf of respondent number 10, my lords, I undertake
Kindly
to.
give a
No.
week's objection.
1 to 7 who appears? That's what is the process you have to pay for R1 to R7. Any of you are representing R1 to 7?
No, my
No, your lordship.
The process shall be paid within a week, or else the writ petition shall stand dismissed against 1 to 7. And for so-and-so, please
11
write it on the gift.
Yeah,
Please,
yeah,
ma'am.
yeah.
It is submitted that the so-and-so has instructions to file wakalat
Libre. Very
for
good.
so-and-so respondent. Yes, next 10.
My lords, there is
Number
some
My lords, interim order may kindly be extended.
My lords, one date may,
None of you have to ask for the interim order. All interim orders will be extended.
Much
Yes.
obliged, my
my
lords.
lords, one
10.
submission, my lord. This is suit is of the year 2008, my lord. Kindly have it on next week, any date, my lord.
A date may be fixed, my lords.
R1 to R7 notices.
My lord, now they are colluding with the plaintiffs and other
Then we
defendants.
will do one thing. Instead of praying the process in 9, the petitioner shall take out hand summons on the counsel appearing for the respondent 1 to 7 before the trial court and shall file a memo to that effect by 19.
My lords, I've taken it to the council. That's what I've tried
Where
submitting.
is that?
My lords, there's a memo with the,
That? Respondent 1 to 7. Here you said 2 to 5. What happened to 1? This is 1. This is 2. 10.
You served it on 9.
It is submitted that as per the order passed to the court, the petition has taken out notice on respondents 1 to 7 and also 10, and a memo to that effect is filed before the court. Accordingly, the notice to R1 to 7 and 10 held sufficient.
I am appearing
And
for
so and so
respondent
has
number 10, my
instructions-
lord.
Huh?
Appearing for respondent
So
10, my
and
lord.
so has instructions to file wakalat on behalf of 10. You
11 to 32.
11 to 32. So and so advocate. List this matter on 20th.
Please, ma'am.
much obliged, my lords.
Yes, interim order is extended till then. Yes, next.
Serial number 10.
Let's have paid the process minutes.
It is submitted that the needful is done. List after service of notice. 11.
Paid.
List after this whole 11 also after service of
Interim
order may kindly.
Yes.
Serial number 12.
I am for the respondent plaintiff, my lord.
12. Nilopan.
List after service of notice to R2 to R5. 13.
Serial number
That is-
13.
I appear for the respondent.
Dananda.
R4 not claimed. It's
ಇಲ್ಲ
in
serial
serial number
number 12
13.
ಅಲ್ಲಿ ಇನ್ನು 12
What yes now?
13. R4 not unclaimed.
Where do you get that? Notice to R4 returned as unclaimed amounts to deemed service of notice. List after service of notice to R6. And what about, and the process shall be paid in respect of R3 and R5 within a week, or else the petition shall stand.
ಅಲ್ಲ no my lords, service is
13. All is over.
my lords, in serial number 12 there is an interim order, my lords. It may be extended.
Only R4.
Will be
I may be permitted to make submission in serial number 13, my lordship.
R5, yes, 14.
Today,
List after
my
service
lordship,
of
in
notice.
serial number 13, my lordship.
Interim order may kindly make.
Serial number 14.
Please.
Serial number 13, I have filed wakalat, my lordship.
Yes, 14. List after service of
Minutes.
notice.
I undertake to
15
file,
also list after service of notice.
cell number 14 minutes, I undertake to file on behalf of respondent number 1 and 4.
1 and 4.
1 and 4 minutes.
14, so and so submits that. He has instructions to file wakalat. List this matter on 22nd of January.
Please.
Interim order, look at it. If it is, extend till that time.
As my lords, the respondent one being the contesting party, I'm the sole plaintiff before the trial court. And against me, my lords, the IA has been filed. So this notice may kindly be dispensed with.
You said you're appearing for 1 to 4.
1 to 4, my lords, respondent number 1 is a plaintiff before the trial court, sole plaintiff.
When that day, when the matter comes, we will
Please.
see that. Yes,
Please, please.
15.
15.
15, await notice, my lords.
Yes, list after service of notice. 16 also same.
For 16, please.
17.
17.
17 minutes, I will permit it to wakalat on behalf of respondent number 2.
What about 1?
I don't have
So
instruction.
and so submits that. He has instructions to file wakalat for R2. List after service of notice to R1. Interim order granted earlier, if at all. Look at it.
Serial number 18.
18.
18, my lords, I appear for respondent, all the respondents. In fact, I had
To R1
R1 to R3. I had, in fact, I had filed wakalat on 6th itself.
It is submitted that so and so has already filed wakalat in respect of R1 to R3. Then IA number 1 of 25 is filed seeking dispensation of production of CC of annexure A, dispensed with. Any interim order in this?
Yes,
But there is some urgency.
We'll hear this matter. List this matter on
May I request for tomorrow, my lords? No, the problem this is no, I'll just, my lords, make one submission to just, my lords.
Yes.
This is a tender matter. Part of the tender, my lords, is stayed by the interim order passed by this honorable court.
End of the list will take up
Please,
this part.
wait.
Yes. 19.
Seal number 19.
My lord, I am for the respondent in this matter. Lord,
Insofar as respondent number 2 and 4, my lord, already have served the copy, my lord. And
lords, I have
these
added
matters
to-
already been connected with the WP number 108931 of 2025. my lord.
What about this? In this process is complete?
Yes, ma'am. In all three matters, I have.
Lord, the writ petitions are not maintainable. The writ petitioner is seeking change of the arbitrator. That's not permissible. And the ground for seeking change of arbitrator is the ground that he is reducing the compensation. Well, under section 3G of the National Highways Act, the arbitrator has got the right to reduce. Not the writ petition itself is not maintainable. It's a statutory arbitration. The central government has appointed the arbitrator. At our instance, NHA has moved the application.
Who is respondent number 3? Additional Deputy Commissioner and Arbitrator under National
Please, ma'am.
Highways Authority of India. You have made an application before him for appointment of an arbitrator.
Appointment of arbitrator is by the respondent number 1. my lord. Here, my
No,
lord, what has
we-
happened
we-
in this
we
case,
were-
my lord,
we
this is
were
the National
responding to
Highway
one was
Acquisition, my lord.
agreed with the determination of the compensation by the competent authority. Agreed by that, in 2024, we initiated the arbitration. So now the writ petitioners are seeking change of the arbitrator. No, that's not permissible.
These matters are already being connected, my lord. Either if the your lordship is going to hear the matter, those matter has to be dealing from that.
Which matters have to be dealing?
These matters, my lord, because already on 8/1, my lord, this was this connected matter is pending before Justice Honorable Justice Nagprasannam, my lord. And these matter, the National Highway Authority.
Pending means what happened? He has passed,
No,
resolved the
he's
matter.
going to hear the matter on 14th. Because there is another matter which is for dictating orders. What has happened is one petitioner, my lord, claimant,
No, I'm asking, is it a part heard matter?
it's a part heard matter.
Is it so? She says
Lord,
that the
I'm-
connected matters are part heard
Yes,
before.
They themselves got these numbers connected there, my lord.
that is a different patch, but my lord, I have no
Please, my
issues.
lord, that is what I wanted to make a submission, but they are on the merits. my lord.
Bench of this court has going to hear the matter on 14th, which is made as a part heard. List along with, what is the number?
I have given the number.
List along, these matters along with that number.
108931.
Huh?
Undertake to file wakalat for respondent number 4, ma'am, in all the matters.
Yes,
Grateful.
R4.
next 20.
R4. Rakesh.
I wait notice.
Seal number 20.
I wait notice. I wait notice insofar as the respondent number 5.
5.
And one more respectful submission is that, my lord, the
That
state has
application
filed an
for-
application for vacating as well as the state. Statement of objection. I want to file rejoinder to the state. They have suppressed the facts insofar as the documents which have been placed along with the state.
So I filed application for vacating stay.
These-
Now the,
It's not listed.
yes, now the, my lords,
By number
listed, yes,
one.
Please.
my lords,
My lord, I want to file rejoinder. They have suppressed.
When did they file the vacate?
Please.
When did they file the vacate?
My lord, vacating
When it was served on you,
on 8/1/2026 it is filed.
it is submitted at the
And
respondent
today
have
morning the
filed vacate petition. And the petitioner was.
kindly, one
filed
submission.
joint.
May I make one? Its appeal is pending before the, my lords, authority by the filed by the petitioner. But having unsuccessful in getting the orders of interim orders, he approached this honorable
You know,
court.
he has come,
And,
court has
my lords,
granted order, you have filed your
Please.
vacate, let him, whatever he wants to file, let him file the
My
interim.
lords, before that,
This is matter
one submission.
on 28th of January.
My lords, one submission. my lord. Before the, my lords, the interim order has been granted, the work order has been issued. And he has supplied, the contesting respondent has supplied some commodities to, because it is, my lords, pre-metric, my lords, the hostels.
No, we have to hear it
Yes.
to appreciate all this.
Because of interim order, he is not in a position to supply the, my lords, the commodity.
28,
Yes.
yes, next.
28.
Interim orders.
Seal number 24.
Interim order granted.
Interim order.
Yes,
Please.
21.
Seal number 21. Prakash Sudhindran, Sachin
My
CMD.
lord, may I request on 19th, my lord?
Why have you not filed the undertaking affidavit?
My lord, petitioner number 2 is not keeping well. May I request 19th, my lord? I filed an undertaking, my lord.
Yes, but on that day, if you don't file, I'll dismiss the writ petition.
My-
Court has
19th,
directed the
last,
petitioner to file the undertaking affidavit on
6th.
7/1/2026, even till today, the petitioner has not filed. Finally, lists this matter on 19th. By that date, if the undertaking affidavit is not filed, the writ petition will be dismissed on that ground. Yes, next.
Service is awaited, my lords. I request
22, discharge the service of
any
notice.
date may be fixed, my lords.
No, if it has to be served, then only we can. Yes, 23.
Please.
Seal number 23 adjourned.
Yes.
Preliminary hearing B group matter, seal number 24. CGP.
Your Lordship, state has preferred an appeal, Your Lordship. State has preferred a petition, Your Lordship. Sought for quashing of annexure A, passed, Labor Court has passed the order, Your Lordship. Granted 60,000 to 88 rupees for 11 years, Your Lordship. State was supposed to give, Your Lordship. It is our contention, Your Lordship. The respondent has,
Let us see the order. Where is
please,
the
Your
order?
Lordship. Order, it is in Kannada, Your Lordship.
Page number 17, my lord, annexure A.
It is in Kannada, Your Lordship, page number 17, Your Lordship.
17.
This is matter in the month of March.
March.
Yes.
Seal number 25 adjourned. Number 26.
Yes,
Number
26.
26. AC Chaklabbi. Nandur. Tesham Kharvi.
Matter pertaining only, the order is, my lords, that during the pendency of the, my lord, divorce petition filed by the husband, I am the husband. So the application filed by the, my lord, petitioner, wipe that there is some arrears in respect of the 125 proceedings that was disposed. And recovery proceeding is, my lords,
Let's see the writ petition. Let's mark you what it is.
Please.
no, my lord, we have paid out of 3,02,000, my lord, we have paid 1,88,000 before the trial court.
As per my
Now-
instruction till today, 3,18,000 is the arrears. lords.
No, my lord, it is the executable decree, my lords. It is a final order. So judgment,
Let me see what is the order impugned in this writ
that,
petition.
please, my lord, please.
I have filed an
The
application
impugned
under
order
section
is
151 seeking to
page
stay
number
the
13.
further proceedings of,
1 minute.
please. Annexure A is the impugned order, lords.
Where is the order?
Annexure
Page
A,
number
lords.
15, my lord, page number 15.
My application came to be rejected.
What is wrong in this? Why not this order be granted?
No, no, my lords, because, my lords, they have filed 120 proceedings that was disposed. And the trial court, that is the Honorable Family Court, has ordered to pay 8,000.
I have already passed an order and I have also directed all the family courts to follow this procedure. Under section 151, court is empowered to do so.
No, my lord, it is only for, my lord, pendant lease, my lord, that is 125, no. Suppose, my lords, is the interim maintenance, that this order is valid, my lords. It is not interim, it is a final disposal. It is a final disposal, my lord.
It is between the parties. You are
Yes.
seeking any relief from the court and at the same time you don't, whatever is the earlier order passed by the court, you don't pay the money. Court can do it.
No, no, my lord, regularly we are paying the payment, only 1 lakh is, no, my lord, out of, he has stated that 3,18,000, out of 1,88,000, 2 lakh we have already paid, my lords.
Yes.
We have already paid 1,88,000 as on today. Out of 3 lakh and odd minimum.
No.
And that is-
Deducting that amount, what 3,18,000 is the arrears.
If it is interim,
Find a criminal miscellaneous.
Lordship,
You have already found a criminal miscellaneous.
Lordship, what happened in this case? He has appeared in the MC case. He's not appeared in that recovery.
no, no, we
petition.
have written, we have.
Therefore,
showed
I
the
have
order
filed an
sheet.
application.
No, that is wrong. We have-
Therefore, I have filed this
we have-
application.
We have produced the order sheet, my lord. We are regularly paying the account to the account, her account, my lords. To the her account only.
No, you can't blow out hot and cold. You want a relief from the court and on the other hand, you will not comply the order of the court in toto.
No, no, it is continuous process, but it's not recovery proceedings, sir. They have filed request where, and,
Because, no, forever you will be dragging on those proceedings. And
no,
here-
no,
here
that
you-
is not our intention. That is not our intention. So the divorce petition is
Either
pending
you
since.
pay the amount or I'll say there shall be stay of all proceedings in the MC till you complete the complete that amount.
No, it is going on, the recovery proceedings, my lord, is going on till the, my lords, the divorce petition concluded. It is still pending before the court for cross-examination. And we are regularly paying, depend upon the, my lord, his income, my lords. That I have a challenge that was also disposed by this honorable court. That is, my lords, it is not bar, my lords. That is what, my lord, it's the executive degree. Because the recovery proceeding is filed by them. 125 proceedings.
Just because they have an option of recovery proceedings, that does not mean that the court is powerless.
No, my lord, they are not appear before the MC divorce petition. They are not. In a number of times, they have took the time for cross-examination.
So what do you want the court to do? Court is
Well, we have to duty that we have to pay the entire amount. That is our duty, my lord. As a husband, he has to pay. But due to his economic condition, unable to that balance amount. But he has regular to pay the 8,000.
No, in these conditions, don't proceed your MC also. Till you have the enough resources, let the MC be state. Get instructions from your client, or you want me to?
Yes, sir,
pass
please,
on?
my lords. On next week, any date, my lords.
This is not Monday. Let's just.
Next to 21, 22, any date, my lords.
22nd.
Please.
Interim order may can be.
Interim order
Please,
granted is extended.
Number 27. Surbhi Hegde.
Representing the petitioner, my lord, it's about rowdy sheeter, my lord. Lord, kindly come to page number 12, annexure D, my lord. Page number 12, annexure D. May I read the relevant page number 12, annexure D, my lord. Just for a moment, I'll Lord, demonstrate. They have given 4 cases, I mean, numbers of 4 cases which are pending against me, my lord. I'll just make this court to go through that, my lord. Kindly come to annexure D, page number 12. In the last box here, my lord, last box, they have numbered it as serial number 1, 2, 3, 4. Annexure D, page number 12. In the last box, serial number 1, crime number 59/2018. Hope my lord gets it.
Yes, sorry.
Yes. So there are 4 cases which they have numbered. Lord,
When was the rowdy sheet opened?
Lord, according to this annexure, I have made a RTI application seeking information whether on my name.
This is a case for 100% objections. We can't pass any.
I'll just make one submission, my lord. I'll just make one submission. Please allow me, my lord. Kindly see this document, how they are implicating me.
No, please understand. We can't only hear the case from your side. The respondents
No,
have to come.
I understand, my lord. I'll give reason. The accused in that case.
The authority who will close the rowdy sheet.
My lord, this honorable court has, coordinate bench of this honorable court has given a guidelines now, which says how the procedure should be followed.
Yes, it has to be followed even for you also. For closing a rowdy sheet, what you're supposed to do.
My lord, simply there is
It is
only.
already open. No. I'm not at all going into the benefits of the matter.
Yes.
I'm saying the rowdy sheet is opened. According to you, that is an abusive process and that is
Exactly,
contrary to the so-and-so.
Exactly.
So what you're supposed to do?
Now I made a representation.
Where is the representation?
My lord, that is also annexed. My lord, annexure B, page number 7 onwards. I'm sorry, it is there in Kannada, my lord. I'm sorry.
So what is the date? What is the date?
I have given, that is 19/7/2025.
So what we do is, let us call for their objections. So everything.
This
will be
exercise
all
was
right.
done. This exercise was done by this honorable court.
What is that? Where is
Now, last time, what happened is,
where are the objections?
kindly see the order sheet, my lord. This was ordered. Why? Because that's the reason, my lord, I told that I'll make one submission.
GA is directed to secure instructions. No, it's not about securing instructions. In these kind of rowdy sheet matters, there has to be a written objections on record.
I
Because
understand.
It is pertaining to law and order problem. We just can't pass orders basing on his instructions.
Lord, my only request is, my lord, from last 2 days,
That's what I'm saying. We'll fix a date for objections. On that day, if the objections are not filed, whoever is a concerned shall appear before this court.
Why that order was passed is, my lord, I'll make one submission regarding that. Please allow me, my lord. Kindly see this document. Accused is someone different, but our name matches.
No, what you have to understand, once you come up with your objections forever, it is a penalty to your problems. So that's very much required in these matters. The Learned AGA shall file the objections by February 18th. If the objections are not filed, by the time the concern shall appear before the court.
Yes. Great.
Seal number 28 urgent, seal number 29. Khan? Yes.
My lord, the grievance of the petitioner is that seeking the reissue of the passport as it is already stands answered by the coordinate bench of this court.
Sarash Chandra.
Yes, in Santosh Srinivas, I am producing the.
It's covered by judgment. They have to approach, my lords, that court
No,
which
what
the
is
criminal
this?
court is
Let
pending.
us see what is the relief they are asking.
I have filed an application seeking the reissue of
Only
passport.
number 1 and 2 herein to renew the passport.
Yes, my lords.
Yes, my lord.
For that a writ petition.
It is covered by the judgment of this coordinate bench of this.
As per the
judgment of.
Take that.
as per the section 6
So I
of
think
the.
for everything, we don't require any other forum, everything High Court. Issue a no objection certificate to the petitioner for renewal of his passport
Yes, my lords.
for a period of 10 years.
So earlier that 10 years is issued, my lord, that is Annexure A.
The coordinate benches have rejected the prayer and have directed to issue the passport in connection by terms of the JSR notification issued by the central government. The central government has issued a notification which says that if the criminal cases are pending against the accused, still it cannot come in a way of renewal or reissue of the passport.
As per 16(2)(f), my lords, of the passport. I have produced the divisional bench order tomorrow, my lord. Kindly attend it tomorrow. Divisional bench order also, my lords. They have to approach the same court. The criminal case is pending.
You know, what has happened before this? Where have they rejected your case? for
My lords, they
renewal?
have not rejected my.
Then what was the cause of action for you to come to this court?
They are insisting for me to get an order from the trial court to travel abroad. But whereas the criminal case which is pending against me is stayed at the hands of the coordinate benches of this honorable court. I have produced the stay order at page number 170.
The first prayer which you sought is seeking renewal of the passport.
Please.
Have you requested the authorities for renewal?
Yes, my lord. I have filed an application to.
What did they do? What did they do? Please show that.
Page number 189, my lords.
189,
my lords.
189 may kindly be perused, my lord. Annexure L.
What did they say?
It says that please furnish copy of order in CC number 2220 of 2022 with a permission to travel for the further processing of your passport application. My lords, they are insisting for the order from the trial court, which is stayed at the hands of the coordinate benches of this court.
Please get that order.
Please, miss.
This is matter on,
Day after
no, day after tomorrow, not possible. This is
22-23, any
Huh?
dates. 22-23 is covered by judgment, my lords.
It's covered by matter, my lords.
23, any date. 22 or 20. 22,
20?
29, my lord. This is 29.
Cell number 29.
29 to?
No, my
No,
lords.
this 22. 22-1.
Asking for the date.
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 I'm thinking where is it? 22 is covered
No,
by
no.
judgment. This is matter on 22nd.
Please, please.
Yes, my lord.
Macho.
Seal number 30.
My lords, I appear for the petitioner, my lords. My lords,
Yes.
the petitioner is a government company, my lords. In a land acquisition matter, there is an execution petition that is pending. And my lords, there was an attachment warrant issued, my lords.
Let him appear in person. This is
My lords, there is
matter.
my lords, there is an interim order. My
2nd of
lords,
February.
there is an interim order for making
Yes,
payments.
yes,
My lords. We have made the
except
payment.
31.
Now they have filed an application, my lords,
Seal
asking
number
for
31.
withdrawal of that
Precious
money,
Maygur.
calculating the entire
Arun L.
proceeding.
Nilopan.
IA number
2nd
8
February.
filed by the my lords
My lords,
defendant.
the trial court matter is listed tomorrow, my lords. My concern is they're frustrating the writ proceedings. They filed an application for withdrawal of the money, my lords, that has been deposited in trial court.
Take that file.
I'm so sorry, my lords, that I had to pursue this like this.
30.
Argue.
My lords,
Where is
the
the order?
writ petition, my lords, arises from an execution petition order, my lords.
May I come to the impugned order wherever it is? Where is the impugned order?
Please, my lords, I'm just. My lords, the typed copy, my lords, is at it starts at number 30, my lords.
Page number 44, my lord. Annexure A, page number 44, my lord, relevant portion.
The typed copy, my lords, is available at page 56. There is an attachment order issued, my lords. We have challenged that attachment order, and this court, my lords, by an order dated 26th November, my lords, September, has passed an order for deposit of money, the entire amount, my lords, before the executing court. That entire amount is deposited, my lords. Now the respondents, my lords, have filed an application for withdrawal of that money. That will frustrate the entire execution proceedings and this writ proceedings, my lords. My only request, my lords, is that an order may be passed directing
No,
that.
I'm not able to understand what happened to the decree. Was it questioned? Without questioning it, how can you seek execution of the?
Decree was questioned. There is a review petition that is pending before the same court. That
When
is
did
also
you, then, when did you file the review?
immediately, my lords, in the year. The review was filed, my lords, in the year 2017, before the execution proceedings. The Honorable Trial Court Judge, my lords, without deciding that.
From 26/9/2025, whereby the petition is directed to deposit an amount of rupees the entire amount was directed to be deposited before the executing court within a period of 4 weeks from today. It is submitted that now the respondents have filed an application for withdrawal of the amount. It is the contention of the then counsel of the petitioner that unless and until the review petition is decided, if the amount is withdrawn by the respondent, it would cause a lot of hardship to the petitioner. Considering the submission till the next date of hearing, the respondent, the executing court shall not pass any directions for withdrawal of the amount.
My lord, may I submit one thing, my lord? My lord, review petition may kindly be disposed of, my lord. Direction may kindly be issued, my lord, because the respondents are the land losers, my lord. They are, my lord, to
Then
take.
in that case, I'll dispose of the writ petition itself.
Please, my lords, there can be a direction.
Writ petition is filed seeking the following prayer. A coordinate bench of this court, the order of Justice Suraj Govindaraj, extract that so and so. Then counsel for the petitioner submits that they have already filed a review petition against the judgment and decree dated so and so. And the same is pending consideration. In the meantime, EP is filed. And as per the order of this court, they have already deposited the amount. It is submitted that unless and until the review petition is decided, if the petitioner respondents are permitted to withdraw the amount, it would cause a lot of prejudice to the petitioner. Land counsel for the respondent submits that there is a the respondents or the land losers and the landowners, and they have lost the property. It is submitted that the review petition is pending. There shall be a direction to the court to dispose of the matter as expeditiously as possible. Considering the submissions on behalf of both the sides, this court is passing the following order. The petition is disposed of, directing the executing court, directing the court to, which court is that?
My lord, it is pending before the senior civil judge at Haryal, my lord. My lord, that is at annexure H, my lord.
Annexure?
H 154, page number 154.
So and so. to dispose of the pending review within a period of 1 month from the date of receipt of the copy of the order till till the orders are passed in the review petition. The court shall not pass any orders for shall not grant any permission. for
Not pass
disposal of
any
the
order.
amount. Yes.
Please, great.
Next.
Much obliged, my lord.
Yes, 32.
Number 31.
My lords, I appear for respondent in this case, my lordship.
Yes.
I number 8 filed by me, my lords, to
There's some
determine the, my lords,
documents, it appears that some documents are produced by counsel for petition, my lordship. The copies are not served upon me.
no, my lords, by way of emergent notice, my lords,
You have an interim order? You have an interim order?
subject to the, my lords, not to pass the final judgment. My lords, emergent notice has been issued by this honorable court. If she
No, my
requests
lordship.
me,
Subsequently, along with memo, some document is produced, my lordship. I am asking for that document. my lord.
All the documents are not served. List this matter in the month of February. Interim order earlier granted is extended. Yes, 32.
Number 30.
Now appearing for the petitioner, my lord.
Yes.
My lord, 6 weeks accommodation, my lord.
List the matter in the month of February. Yes, 33.
February.
Lord, interim order, my lord, can they extend?
Yes,
Interim order
33.
extension.
Lord, there is an interim order, my lord.
33.
Much
Please.
obliged, my lord.
Petitioner in this case.
For
The
the
application filed by
respondent.
the defendant under order 18 rule 60.
Order is there. We will see someday.
My lord,
This
there
is
some urgency, any date your lordship may.
This is matter on 17th. Difficulty is at least 40, 50 date matters every day.
Lord,
This is matter on 3rd February.
please.
Yes. 34.
Number 34. I appear. Shekharagoda.
Please, request for one short
Yes.
accommodation, let's say.
This is a matter on 5th of February.
Please, interim order may kindly be extended.
35.
My lords, one
35.
submission, in 34, my lord, one submission, on the basis of registered sale deed, that respondent number 2 was purchased the property. Now they are obstructing to mutate my name in the record of rights. That will not affect any rights over the property, my lords. See, the
No,
suit is
matter
pending.
will come, we'll hear on that.
Now, not alternate, if the honorable court was pleased to pass the not alternate,
The only an order for not to alienate.
I'm not
the suit
alienating the
properties.
property, my lords. For mutation of my name in the record of rights, they are obstructing.
When what they're saying is something contrary to the order, court need not clarify. You can tell the concern that that's not the order of the
My
court.
lord, before filing in a suit, the property was sold by the respondent number 1 in favor of.
35.
35.
For the petitioner, your
Thirty.
lordship. We are challenging I number 11, your lordship.
Matter on 18th February.
18th February.
Interim order may be extended. Obliged.
Interim order extension. Still number 36. Girish Vibhat.
This matter, my lords, my
Chapter 2.
residential property was put to auction, which I had challenged, and this one granted a conditional interim order directing me to deposit 25% of the amount, which is 16 lakh is the due amount. So, my lords, 9th was the last date, and I approached the bank, and my account was suspended. So, I not able to deposit. On 9th itself, my lords, I have taken the DD in the name of the bank for the amount which I had to deposit. So, my lords, matter was listed day before yesterday. And it was repeated today, my lords. If they are ready to accept, my lords, I will hand over the amount.
Order dated 8/12 may kindly be perused, my lord. Within 4 weeks from 8th, they have to deposit the amount, but within that period.
Where is the DD?
Here in my hand, my lords.
Give it to her.
That day only I was submitting, my lord, because you want.
Please, my lord, already auction has been taken place, my
No,
lord.
that can be. Why don't you take the DD?
Only because of
Record
the.
it. It is submitted by the. Give it to her.
Please.
Submitted by the land council appearing for the bank that the petitioner has not complied with the interim order. Land council for the petitioner submits that he is ready with DD for an amount of rupees
4,28,000.
4,28,000, my lords.
28,000 as
25%.
ordered by the
Please.
court. Land council for the bank submits that already auction is conducted.
Yes, ma'am.
It was a e-auction.
Huh?
It was a e-auction, my lords, which cannot be.
Auction was conducted.
E-auction.
The respondent bank shall furnish the details of the auction purchaser in favor to the petitioner, and the petitioner shall implead him also.
Please, if they have conducted, because the direction was that, my lords, only auction, further proceeding was stalled by this
It
honorable
happened, that's
court.
what she's saying.
And my lords, I need a further time to deposit the further amount. Another 6 week time to
First
deposit
of all,
20%.
let him be brought on record. If you take the details and implead him.
Please, till then the interim order granted may be extended.
Interim order earlier granted is extended.
Grateful, my lords.
Aldikeri.
This is the defendant's petition, my lord, arising out of a partition suit. But there was a prior partition amongst the family members in the year 1989. Thereafter, there was a...
Order?
No, my lords, I do not have an interim order, therefore I'm pressing this matter.
We will see. This is matter on 12th February. Yes,
My lords, earlier date, my lords, there's some urgency. There's been complete suppression of facts by the plaintiff in this case. I'm requesting for an earlier date.
29th
29.
January.
Jan.
Yes, 38.
Number 38. Shuprasad. Says Patil.
The compromise petition was challenged by the
Our party?
petitioner, my lord.
Interim order?
Yes, my lord. Yes, my lord.
Yes, this is matter. In the month of March, interim order earlier granted is extended till then. 39.
March.
Please.
Seal number 39. Kulkarni Dinesh. AGA.
Yes.
File statement.
What is the RSC means?
Appointment of trustees, Lord.
RC.
Religious and religious charitable aid.
Oh.
The,
What is the interim order?
Lord, the fixing the term of trustees is contrary to the scheme prepared by the court in OS number 5 of 1906. Annexure A is the original order wherein the administrator is appointed and directed.
This is a registered notified endowment.
Yes,
Notified.
notified.
institution.
But what happened in this annexure A is the order passed in original suit, wherein the district judge of Dharwad is appointed as a administrator, and he has given power to appoint the trustees for 5 years by calling the applications.
Which year is this order?
Please,
Which year is this order?
this is of 1966,
When did this?
and that is continued till today.
No.
Every 5 years, applications are invited for appointment of trustees.
No, even as per the Endowment Act also, it is how many years? As per the Endowment Act, appointment of trustees.
It is, my lord, specifically it is a suit, my lord, wherein dispute was raised. In that, this scheme is prepared. It is not, my lord, related to Endowment Act.
What do you say?
Under the.
Kindly see, what is challenge is annexure E. Annexure E is with respect of these petitioners. And secondly, seeing page number 41, relevant portion, my lord.
Period is reduced to, my lord, 4 months.
Notification number.
Yes.
Please.
That's annexure E starts.
As limiting the period of tenure for 4 months
Yes.
to category 3 belonging to petitioners.
Yes. That is wrong. According to us.
Just kindly see annexure E. Annexure E starts with page number 34. The relevant portion is, my lords, 41.
Number?
Page number 41. My lords. The above persons at serial number 1 to 4, 7 and 8, now appointed to the Panchas, that is the committee member, shall hold the office for a period of 5 years. And serial number 5 and 6, this is petitioner are concerned, my lords, shall hold the office for a period till their present tenure of 4 months as a member of Gram Panchayat, Devargudda. That's a precondition to become the member in category 3 is that he should be a present member of Gram Panchayat. Since the tenure of the petitioner completes for 4 months as on date of passing of the order, the order passed by the respondent authorities is just and proper. Their period itself, my lords, completes after completion of 4 months, as they were elected in the year 2020, my lords.
5 years.
5 years completes after 4 months after passing of this order.
Not
By
the
virtue of default.
Scheme is not till they holding the office of Panchayat members. Since beginning, it is the tenure is 5 years. As on the date of appointment, if they are.
When the Panchayat member is part of the committee, in the capacity of the Panchayat member, as long as you are a Panchayat member, you will be.
No, that discretion is not available. That discretion is not available under the scheme.
No.
The scheme does not describe
Please,
so and so
let's go
category.
to the judgment. Where is the judgment?
No, kindly annexure A is. Annexure A, first page,
Page number.
page number 10. Your lordship will get fourth paragraph. The two members shall be nominated from the village panchayat committee. Devargudda, Wide district order dated so and so. And next,
No,
the
I'm not
panchayat,
able to see it.
please.
Two, where is that?
The two members shall be nominated from the village panchayat committee.
That's point,
Devargudda,
that is point number.
paragraph number 1, 2, 3, 4. Sixth paragraph, your lordship. Sixth paragraph. The two members shall be nominated.
Correct.
Next, my lord, the panchayat shall hold office for 5 years. Next term.
Yes.
Then there is no, my lord, restriction that till they holding the office of panchayat. As on the date of panchayat, if they are members, they will, if they are appointed, their tenure will be 5 years.
My lords, the wording is very specific from the members of Gram Panchayat. It is not
So,
that ex-member of Gram Panchayat.
Till today, till from 1966, till today, nowhere such a restriction is imposed. Every time members are appointed and trustees holding the office for 5 years.
The trust, you are holding
And kindly
the
see the
position of
notification,
trustee,
present
a
notification.
member of the panchayat.
Not
That
kindly
is
see the,
panchayat. So if you are in the office, you are there as a trustee.
then kindly page number 21.
Yes.
Sorry, it's in Kannada. Clause number 3. ಇನ್ನು ಉಳಿದ ಇಬ್ಬರು ಪಂಚರನ್ನು ದೇವರಗುಡ್ಡ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಮಿಟಿ ಸದಸ್ಯರಿಂದ ಆಯ್ಕೆ ಮಾಡಬೇಕು.
This means the other two members has to be selected from the gram.
There is a stay in this, I'm asking.
Yes, there is a
stay is there.
Yes, list this matter on 22nd.
Please.
Password matter. List number 2, serial number 18.
This tender matter, my lord, there was an earlier round of tender where I have been a successful bidder, and some of the stalls in KSRTC bus stand was allotted to me. Subsequently, it is stated by them.
It will be extended. Yes.
Subsequently, it is stated by them that by mistake they have auctioned, put that stalls in auction, and they want to use that property for public uses like luggage carrier and all. So, my lords, I came into an agreement with them, stating that, my lords, those plot I will give over my right, and that should not be used for any commercial purposes. I am giving up my right. Now, my lords, after I giving up my right, they called a fresh auction, and now they have put those plots on which I have given up my right for commercial purposes, which I have challenged before this court, my lords. And today they have given my application for vacating stay. They have served me a copy alleging some grounds, my lords, which I have to go through, my lords.
Today, my lords, the vacating application, may I just pass on?
And my instruction also that, my lords, the authorities of the NWKSRTC have stated to my party that there is some chance of settlement, and they have to state regarding that. My lords.
Submitted with the land council for the petitioner that they have received the vacate stay petition today, and he wants to get instructions in this regard. List the matter on 10th February.
The urgency, my lord, that why I am pressing this is
Then,
because, may I request, my lords, for
Have it on 29th. 29th.
Lords,
Not
any-
possible before that.
the reason being this, my lords, part of the, my lords, tender notification is state. The other part, my lords, we have completed. Auctions have been called for. For these 7 shops only.
29th will hear.
And, my lords,
By the time come up with this.
lords, may I, my lords,
interim
request,
order
if
existing-
it's not, my lords, may I request for some shorter date, my lords, on 19th, my lords, or 21st or 22nd?
I think it's not possible. There are so many matters. 22nd.
The interim order existing, my lords.
It will be extended.
But the,
Great for me.
lords, the vacating application, my lords, I
You can
have,
file it in the registry.
please,
Time is
great,
there.
great.
Yes.
With my lordship's permission, my lord, seal number 37 list 2, 29, there's some difficulty. Can I have, can it be had on 28th or 30th, my lords?
My lords. My lord, serial number 78, my lords. I was just held up in the court. I just came. Next date is given in March, my lords. I have some urgency. I filed objections also. Kindly, any shorter date.
If you're not there, what to do?
That's why.
Look at it, give some.
Number 38.
See, 38.
March. Ian short. ಫೆಬ್ರವರಿ ಫಸ್ಟ್ ವೀಕ್ 11 ಫೆಬ್ರವರಿ 11th ಫೆಬ್ರವರಿ ಮಾಡಿ ಫುಲ್ ಆಗಿದೆ 11th 28 ಮೇಡಮ್ 37 ಎಷ್ಟು 28 ಹೌದಲ್ಲ
37 ಮೆನ್ಷನ್ ಮಾಡಿ
ಎಷ್ಟಾದ ನೋಡ್ರಿ